Yes, may it please, your lordship. No, I am praying for listing of this IA tomorrow, my lord, as the connected repetition is already listed before court number 18.
Yes.
Deeply.
Lordship, item number 4. I have informed the counsel for the petitioner. Lordship, may kindly take it up at 2, my lord. I am awaiting the instruction.
Content matter.
No, it's a read petition item.
Item number 4, you said.
Item 4.
What is the content matter? Police.
The WPC 4786, my lord.
Yeah, sir. What is this? Like wasn't cooperative with 4 years. Okay. I don't pay
4788.
at 2 o'clock. Okay.
At 2, my lord. I have informed the petitioner.
Okay.
Lordship.
What has the piece of protocol? Supplement of the Asan. No, Asan. I can't read it on this. No, please. Yes.
May I please, Your Lordship?
Yes.
I beg to mention for listing of a writ petition pending. It is pending since 4/4/2025 at the stage of admission. And
4/4/2025.
Yes, Your Honor.
What is the urgency?
Your Honor, the matter relates to illegal eviction of the petitioners from their land.
Is
And
it
the
urgent?
opposition were asked to file a.
That is not a matter to be
opposition.
listed by mention memo. Sorry.
Lordship, I wish to mention for listing one item that is.
Is it motion?
No, Lordship.
If it is not motion, you have to make out a case of extreme urgency. Otherwise,
Because
mention
land
memo.
acquisition matter, Lordship, and there have.
No, what is the urgency?
And
That
then
you have to
because
file a
without-
mention memo.
Without any stay, Lordship.
No, sorry.
Because I have filed an application for stay of the proceeding, and that is you.
IA.
Lordship.
When did you file the IA?
Long back. Long back. Last occasion case was listed, Lordship, on the 8th.
Not a matter of out of turn listing. Sorry. Yes.
Your Lordship, I beg to mention for listing on WPC.
Yes.
Matter was last listed on 18/8/2025, and that the honorable.
What is the urgency?
Your Lordship, in 18/8/2025, your Lordship was.
That is
passed
not
an
the
order.
question. That is not the question. Question is what is the urgency?
Urgency is your Lordship, it is the latter matter is for compensation. And
Sorry. Yes. Next, madam.
Please, Your Lordship. Lordship, may I bring for listing of a IA, Lordship?
The fresh matter.
For a pending matter, Lordship.
Pending matter IA. What is the urgency? You have to make out a case of urgency. Listing mention memo is only for urgent matters. Otherwise, it gets listed on its own. Is there any urgency?
So actually, the illegal construction has already been
Yes.
completed, right?
Sorry. Yes.
So,
That will be.
Yes.
That's one last occasion, Lordship, reasonable court was listed.
Para.
Have you paid the compensation?
No, not paid yet.
What is your instructions, madam?
Lordship, the second page, it's a letter dated at 21/6/2022.
25/6/2025.
Lordship, the contingencies fund has been granted by the finance department.
Yes.
Yes, and it will be released.
When?
Lordship, since there is notice or it is to be issued, my lord, I am appearing on behalf of
No,
2 on instruction.
It is not necessary that we
Yes.
issue notice. If you comply with the order, there is no.
Yes, Lordship is complied with, my lord. 25/6/2025 letter, first letter, my lord. It is written by the secretary to the registrar, Lordship. After that, CF fund has been approved by the finance
Yes.
department.
What is your name?
Islam.
Ahad Sri R. Islam Learned Counsel for the petitioner. Para. Miss M.D. Bora, Learned Counsel, who has appeared for the respondent.
Only two, my lord.
Respondent number 2 has submitted that written instructions have been received by her, as per which
CF fund had been.
the government was moved for creation of head, and accordingly CF proposal was submitted to the government on 25/6/2025 for making budget provision. Subsequently, budget provision has been approved by the government by way of CF, and financial sanction proposal has been submitted to government by letter dated 21/8/2025. The ceiling proposal would be moved and the amount would be released as soon as sanctioned by the government. Full stop. In view of the aforesaid development, the consideration of this matter is deferred by 4 weeks.
Lordship.
The written instructions received by Ms. Bora, the learned council is kept on record.
Lordship, a date may kindly be fixed.
After vacation, my lord.
List on, today is what?
Today is 26th, Lordship.
Lordship, after the vacation, in the meantime, if the release, then he will get the benefit.
List this matter immediately on the reopening of the autumn vacation.
Obliged.
Obliged.
In this case, it's 6 time lordship. The cycle of the dispute revenue cycle.
You have not got the instructions?
No.
Bora?
Basically, it's a change in the order of the cycle officer. I have just a
Okay.
formal party.
We grant some time, you are protected by an interim.
Yeah,
order. Okay. Third, Sri A.K. Dear Learned Counsel for the petitioners. Full stop notice. This matter was taken up for consideration on 13/8/2025, and time was granted to the Learned State Council to obtain the instructions. Sri Goswami, the Learned State Council, has submitted that instructions are awaited. We can issue notice. The grievance of the petitioners are a notice dated 30/7/2025, whereby they are sought to be evicted. Full stop. It is the contention of the petitioners that the impugned notice, apart from being vague, are not even clear as to under what provision of law the same have been issued. Let notice be issued, returnable by 4 weeks.
Let it be after vacation, my lord, if my learned counsel.
4 weeks will be after the vacation.
Yes.
4 weeks. Yes, Ms. D. Hazarika, Revenue 1,
I'm for 229 except 5 lordship. I'm for
2,
5.
3, 4,
6, 7, 8, and 9.
4, 5 also. Oh, 4
5, yes.
was 5 is it? 6, 7, 8, and 9.
I'm for 5.
And 5 as Bora, Standing Council, GMC, extra copies. Interim order passed earlier to continue till the next date of listing.
Deeply obliged.
Yes, Mr. Abidin. Yes, instructions.
Receive lordship.
Received, yes.
Lordship, there is some allegation that some unauthorized persons entered in the meeting lordship. He is not the authorized person. He is the officials of this respondents authority lordship, and he visit there of writing of the proceedings lordship. There is no any unauthorized persons lordship. And everything was done as per procedural lordship.
My lord, who gave the report? I don't know. Is it the same person what my lord has already mentioned in the order? Is it the circle officer himself?
Yes, who has given the report?
Which report?
Not the report, not the instructions. See, we want, even the grievance of the petitioners is their appeal, is that their appeal should be fairly considered. And while considering the said appeal, the appellate authority should not involve the same officer, namely the circle officer. Now, is the question is whether the appeal has been considered, number one. If it has been considered, then whether that appellate authority has involved the circle officer. These are the two questions.
That's it.
What are your answers?
That is not real.
No, that is what we want. That is the issue involved. Answer to the issue, matter ends.
That's it.
We issue notice, we make it returnable.
That's it.
Heard 3J Abedin Learned Counsel for the petitioners who are aggrieved.
My lord, only one thing before I see.
Yes.
It is the circle officer's status report. Based on that report is there
No,
in the report.
District Commissioner has sent the Paradise comment sent by the Deputy Commissioner.
If your lordship sees it, it is on the basis of the status report.
No, we
of
are
the-
not not on the question as to who has sent the parawise comment.
Look.
We are on the aspect that what is the procedure involved. That is his allegation. Even involving the circle officer per se will not vitiate the entire proceeding. But if the allegations have some semblance of truth, then matter will be different. Hertz 3J Abedin Learned Counsel for the petitioners who are aggrieved by the election of the president and vice president of the Nagarbahi Panchayat in the district of Dorong. The petitioners have made serious allegations in the manner of holding the state elections, in which specific allegations have been made against a circle officer. Full stop. It is also averred that though an appeal has been preferred before the appellate authority within bracket district commissioner, the appellate authority has again involved the same officer against whom there are allegations. When this matter was taken up for consideration on 18/8/2025, instructions were directed to be obtained by the Learned State Council. Though certain instructions have been obtained, those does not pertain to the issue which is pending, which has arisen for consideration. Let notice be issued, returnable on 16th of September. There are private respondents. Can you serve Dusty? On 16th of September. PNRD. Thapa, on behalf of S. For 1 and 5. District Commissioner
2 and 3.
2 and 3 and Goswami. Extra copies. Steps for service of notice upon respond number 4, TO210, by registered post with AD, steps within 2 days. 3. Abedin, the Learned Counsel, 6. Liberty to serve Dusty upon the private respondents. Liberty is granted. The Dusty service is, however, required to be routed to the registry, date devolvable, and before the next date, an affidavit is required to be filed in proof of same.
My lord, only thing, my main purpose of filing this repetition is that because of that anomalies in that election, respondent number 9 and 10 were elected as the president and vice president. My lord, by issuing the notice, they have not yet taken charge. By issuing the notice, and ultimately, my lord, the purpose is delayed by them, if your lordship is aware, my lord. Because the deputy
You
commissioner.
cannot pass an order without hearing them.
It's true, but if
Can-
the appeal was. for
So we
too long,
have said that dependency shall not be a bar for disposal of the appeal also we have said.
but they will not, because if it was done purposefully, my lord.
Let us see on the returnable.
But only thing, if your lordship permits only one thing, my lord, no major decision will be taken up.
That is difficult.
That will
Shri
be-
Abedin prays for an interim order, while this court is of the opinion, this court is however of the opinion that no blanket interim order is called for. Full stop. It is however provided that all decisions taken by the concerned Gaon Panchayat.
Yes,
Gaon Panchayat shall be subject to the outcome of this writ petition and further orders that may be passed. You to ensure, Mr. Abedin,
Yes, sir.
ensure that these steps are taken as well as by Dusty, so that they are, next day we can pass
Yes,
some
sir.
orders on
Yes.
completion of service. We have given it returnable short date, 16th, I think, 16th question. And file the
Let
affidavit
only-
before 16th on Dusty. Yes,
Let
please.
only one word may kindly be added, my lord, where the entire allegation is against the respondent number 3, the circle officer, for involving an unauthorized person. That was the allegation. He involved the unauthorized person.
Who is involved?
That circle officer, under the notification, it was given that 2 persons were authorized. Circle officer was the authorized officer and assistant officer was somebody.
Court can unauthorized person later. Note court so much appropriate unauthorized.
He has brought that lat bundle.
Bold take it. Yes.
Deeply obliged. my lord.
Yes, the other day, you are making some submission that
Yes.
is,
Then it should go to the division bench. So I have gone through the judgment. Yes, Lordship, he is absolutely correct.
okay. Heard Sri as Bhattakur learned counsel for the petitioner, also heard Sri D. Sekar, senior counsel assisted by Sri Adhikari. Bharadwaj. Learned PP and I, full stop. Para. Both the learned counsel for the parties have submitted that in terms of the order passed by the Honorable Supreme Court in the case of State of Kerala and others versus Rupesh, reported in 2021, SCC online SC 3099, the matter is required to be placed before the Honorable Division Bench. Para. Raised it to verify and place it before the appropriate bench.
Lordship, only thing is that I have agreed to this proposition that it should go to the division bench.
Yes.
But I had raised a preliminary objection on the maintenance. That point I can raise before the
Yeah.
appropriate.
Um,
Lordship has already given in paragraph 7.
yes, that is already open. It is only for placing now.
Lordship,
Yes.
highly obliged.
Mr. Goel? Where is Mr. Goel? CGC, madam, you are there. None appears for the petitioner on call, whereas the central government is represented. Para, in the, yes, Mr. Goel, where are you? You are passing orders.
Mr. B. Go is appearing for West Bengal, Your Lordship.
Mr. Chetia,
Lordship.
where is your friend, Mr. Gogoi, West Bengal? Is he appearing?
Appearing, he told me.
We can defer it till tomorrow or Friday, whenever you say. Hmm?
Tomorrow,
Tomorrow we can try.
Lordship.
Okay.
Lordship.
and some corrections are there in cost title. Can I
By
will file IA, my lord.
file I heard heard Sri A. Goel, learned counsel for the petitioner who has submitted. Also heard Sri S. Chetia, learned. You are senior standing counsel.
Lordship. CVS.
CGST. Purto. Para. Sri Goel, the learned counsel has informed this court that as per information received by him, the state of West Bengal has engaged a counsel who, however, is not present today. Para. In the interest of justice, consideration of this matter is deferred till tomorrow.
Thursday, Your Lordship. Tomorrow, my
Thursday.
learned friend. has
Okay. Till Thursday.
Obliged.
Deeply.
Yes. 2015 matter.
Lordship.
Other side?
Mr. Majumdar.
Yes.
The presently is directed against the declaration of the ceiling surplus land lordship. The order was passed by the DC Kamrup Metro lordship. The facts of the case is this lordship. The petitioners are the industrialist lordship. So it has given a proposal to the government of Assam for setting up a mega cement factory project lordship near Khetri, and which was approved by the state government as well as the central government. All authorities had given clearance for establishment. Then all of a sudden, lordship, a notice was issued to the petitioners, to the LLP company, to the Topsum Private Limited lordship, that you are acquiring the land of measuring almost 190 bighas. So it is in excess of the excess land, and it will be acquired. It will be declared a selling surplus under the Act of 1956, lordship. But the notice was never served to the actual owner of the landlord. Now,
Who was the actual owner?
actual owner is the Topsem. It was purchased in the name of Topsem Cement India Limited, Private Limited lordship. Subsequently,
Purchased from whom?
from private patahol.
Okay, USG.
Pardon, ma'am?
The petitioner had purchased land earlier.
Yes, Lord.
Thereafter,
In 2008.
Yes, then you set up a proposal for setting a
Mega
cement. Then part of the land was thought to be?
Part of the land, lordship, out of 193 bighas, only it was allowed to hold 50 bighas, and rest of the land was declared a selling surplus land without serving any draft issues as required under the Act of 1956, and without giving any final statement, without notifying the accessory in the Assam Gazette, lordship. So here, lordship, may be pleased to come to the here, lordship, may come to page 2 of the read.
Yes.
Topsem, lordship, the land was originally purchased in the name of Topsem Cement Private Limited lordship in 2008. Thereafter, that limited company was converted into a LLP lordship. So here the petitioner is Topsem India. Petitioner number 1 is Topsem India LLP lordship. Petitioner number 2 is the one of the partners here owner. And to prove my submission, lordship, may be pleased to come to Annexure 1, page 27.
Now, is this an issue that who is the owner? Are you raising any dispute with?
Lordship, the notice was issued in the name of the petitioner number 2.
Yes.
Not in the name of the private limited company or in the name of the LLP law.
Okay, okay.
So that is my grievance, that the notice was never served to the.
Who's the petitioner number 2?
Petitioner number 2 is lordship, one of the partners of the LLP. But the notice was not issued in the name of the LLP, partnership firm, or in the name of the private limited company, lordship. So this Annexure 27, this is a certificate of Annexure 1, lordship, page 27. This shows that the Topsem India Limited become Topsem India LLP. LLP identity number, this and that, lordship. And this is this certificate of 2011, lordship.
Okay.
And here, lordship, may come to the next page, page 28. Name of the partners, lordship, Bajrang Lohia, he is the petitioner number 2, Rajendra Kumar Agarwal, Bina Garodia. There are 9 numbers of the partners, your lordship.
Yes.
Now you see the notice, lordship, page 29. This is Dated nil, Lordship. No date is given, dated nil. Issued by the Deputy Commissioner, cum Collector, Kamrup Metro. Notice under Rule 21 of the Assam Fixation of Ceiling on Land Holdings Act 1950, Bajrang Lohiya. It has been reported by the Circle Officer Sonapur that excess land measuring 92 bighas 1 kata 4 lesa has been transferred to you, means Bajrang Lohiya, in village number 7 Ujari and Sonapur under Dimoria Moja Sonapur Revenue Circle, contravention of the section 20 of the Act of 1956. Accordingly, you are hereby directed to show cause as to why you should not be ejected under the provisions of the section 21 from the access line, which have been transferred in contravention of section 20. Your reply must submit within 15 days. So my first submission is this, Lordship. The owner of the land is Topsem LLP, which is a partnership firm, and the notice has been given to an individual partner. So this is, it cannot be treated as it cannot be treated as the owner, Lordship. Even it is not written that Bajrang Lohiya is one of the partners, Lordship. Then your Lordship may please to come to page 30, Annexure 3.
30, yes.
Page 30.
What is this?
This is the show cause filed by the petitioner number 2. Lordship got it?
Yes, yes.
Yeah.
What is the date?
Date is, Lordship, date is left side given, Your Honor, Lordship, 28th of October 2000.
That is the received date.
Received date, Lordship.
20 October 2014. 14.
Yes, Lordship.
Reply.
Reply, Lordship. Where the petitioner number 2 clearly specified that he is not the owner of the land, and the notice ought to have been issued in the name of the LLP partnership firm. I am reading para 1, that the notice has been issued in the name of Sri Bajrang Lohiya, who is not the owner of the land measuring 92 bighas 1 kata 4 lesas, as mentioned in the above referred notice. Para 2, that the above referred notice is most vague notice which does not disclose the cell deed number, patan number, dag number, and as such, no effective reply can be given to such vague notice. Para 3, that the land in question was purchased in the name of Topsem India Limited, which was a limited company. As such, the above referred notice in the name of Bajrang Lohiya is illegal, and it is specifically replied that in a limited company, any individual director cannot be personally liable, and a company incorporated under the Companies Act functions through its board of directors and not through an individual director. And as such, the notice is absolutely illegal and not addressed to the proper person. However, we are giving our reply as follows: that the above referred notice has been issued after submission of an inquiry report prepared by the ADC on 19/9/14, which report is as follows: that the land measuring 147 bighas 2 kata 11 lesa situated in the 2 revenue villages Shanabor and number 3 Ujari under Dimoria Moja under Sonapur Circle, by which the ADC Kamrup has submitted a report before Your Honor that the petitioner purchased the agricultural land and sale deeds were registered in the office of the senior registrar Kamrup Metro without obtaining permission, that is NOC, and the ADC himself has clarified in his report that during the period when the sale deeds were executed, no NOC was required as per the judgment of the High Court during 2008-9, and the name of the petitioner company was mutated over 143 bighas. That as regards the statements made in para 8, it is replied that the Developments are relating to the law laid down in the Assam Fixation of the Ceiling Land Holding Act 1956. Under the clause number C, the findings have been given by the ADC stating that the sale deeds were executed and registered without receiving the declaration to be submitted by transferring as contemplated under section 2(2) of the Act 1956, and the circle officer Sonapur mutated the land under reference without receiving any mutation petition stating that the area and description of the land is contemplated under Rule 22 of the rules frame under the Act 1956, but those findings are not correct, as will be evident by the petition, as will be dealt by the petitioner in the subsequent para, which is absolutely wrong, as because if excess land is found beyond 15 biga, a sealing proceeding is to be started by giving the notice to the landowner to submit draft statement, and only after hearing a final statement is to be prepared showing the returnable portion as per the choice of the landowner and excess land to be declared as sealing surplus. As such, report is contrary to the Act of 1956. Para 4, that the ADC in Para D of the said report has stated that the excess land measuring 93 bigas shall be deemed to have been transferred to the government as per section 21 of the Act 1956, and the revenue records may be corrected accordingly. In Para F2, ADC has reported that even in case of field mutation in rural area, a mutation petition and declaration as contemplated under the Rule 22 of the Rules 57 should be made mandatory, and appropriate direction in this regard may be issued to the all the deputy commissioner. The ADC is probably not aware regarding the facts of the transfer of the land in the name of the petitioner, and the government orders are dealt below. Para 7. That the petitioner company decided to establish a mega project by investing more than rupees 100 crores, and as per the decision of the board of directors of the petitioner company, the process was initiated to purchase the land for the establishment of the said mega project for setting up cement grinding units, and has obtained NOC from 63 numbers Topatoli Gaon Panchayat on 3/11/2007. That the petitioner company applied before the District Industries and Commerce, Kamrup, for registration of the said cement grinding unit for obtaining Central Capital Investment Subsidy Scheme and others, and the DIC Kamrup had granted a certificate of the registration under number so and so as per the industrial policy of the government of Assam, and the said registration certificate was issued by the DIC on 21/12/2008. Para 9. That the Ministry of Commerce and Industry, Government of India, by its letter number so and so, had received the memorandum from the petitioner for the manufacturing of the OP cement and other cement for manufacturing under NIC broad description. Para 10, that the Ministry of Environment and Forest, by its letter dated 12/6/2009.
This land does not fall under tribal
No,
belt.
no.
Outside the tribal belt.
Outside. All right, tribal belt is on the right side. This land is on the left. Para 10, that the Ministry of Environmental and Forest, by this letter dated, have issued an environmental clearance for setting up the said mega industry over the said land, and the cost of the project is rupees 131.64 CR on 12/8/2009. Accorded the environmental clearance for the said project. Next page 33, Para 11. That the government of Assam, Department of Industry and Commercial, by this letter that is so and so, issued a letter to the director of the petitioner company granting a special incentive under Chapter 8 of the Industrial Policy of Assam 2008, informing the petitioner company that the land of the company at village so and so, Moja so and so, Kamrup has been given mega project status, and the High Power Committee of the Government of Assam is pleased to offer a special incentive to the petitioner company, giving exemption of 99% of the VAT for 7 years, exemption of entry tax for plant and machinery, and DG set for a period of 3 years from the date of issue letter of assurance of the tax exemption, and the exemption of the entry taxes of new materials for a period of 7 years from the date of commercial production. Para 12. That the company has applied to the Government of Assam for mega project status, along with the application, had submitted the project report with which consistent of the plant layout map and total land area requirement. Para 30, that on 14/7/2009, the petitioner has submitted an application before the Commissioner and Secretary, Government of Assam, Department of Industries and Commerce, stating that the petitioner company have decided to set up the cement grinding unit etc. at village Ojeri Moja Dimoria with the capacity of plant 2000 plant TDP, it means a ton per day, TDP, to which the environmental clearance from the Ministry of Environment and Forest Government of India has already been issued, and the same has been published in the newspaper as per the provisions of the environmental notification dated 14/9/2006, and the total project cost will be rupees 132 crore as on 14/7/2009, and further stating that the project will give employment opportunity to 500 local people and 150 persons will be employed indirectly, and the government was requested to accord mega status to the project and grant fiscal incentive as per the NEIPP 2007 and incentive for the industrial policy of Assam 2008, page 37. Para 40. That the Department of Industry and Commerce, Government of Assam, by its letter dated, has issued a letter to the Principal Secretary to the Government of Assam Finance Department informing that the High Power Committee HPC in its meeting held on 11/2/2000 under the chairmanship of Honorable Chief Minister Assam has been given mega project status with the incentive as mentioned in the said letter, and the Principal Secretary to the Government of Assam was directed to issue necessary information for the above mega project at an early date. Para 15, that the Industry and Commerce Department, Government of Assam, by this letter dated 7/6/10 and issue letters to all the government officials as mentioned in the said letter regarding the minutes of the first meeting of the HPC for mega project, including the minutes of the first meeting of the HPC for
Mr.
mega
Roy, you
project.
did not need the entire, this goes to 39 page, another 6 pages. You can read the relevant paragraphs. All the paragraphs are not required to be read out.
These para are important lots. Then your lordship may come to para, I am skipping other, para 16 lots.
16 we have read, there is nothing much.
The High Power Committee was has approved lordship, which was chaired by the then Chief Minister itself, lordship. And in case of the other, in para 6 lordship, 16, I have mentioned that when other companies have also established the cement factory and other mega project, they had also purchased the agricultural land and they set up the industry. They are now running manufacturing lordship. I have stated in para 16 lordship, just in the middle, that the line 1, 2, 3, 4, 5, 6, 7, line 7, para 16 lordship in the middle. The Honorable Minister of Industry and Commerce, Government of Assam, spoke about the 4 mega projects, that is the 3 cement factory and 1 brewery unit to be discussed in the said HPC, and in this regard, the government has already granted incentive to the Kelcom Cement Limited. Honorable Minister spoke about the incentive of 4 units, and the Honorable Minister placed before the House to grant incentive to the 3 mega cement units in similar lines. as given to the Calcom Cement India Limited. The Honorable Minister further placed before the House a list of the investment of the private sector till date in the state was placed, and it was shown that there is not a single investment in the private sector of more than rupees 100 crores. And the Honorable Minister also passed a list of the proposal which are in hand of the industry department where investment of more than rupees 100 crore are expected. And expected. The Honorable Chief Minister asked Sri Ravi Kapoor, Commissioner and Secretary, Department of Industry of the HPC, began proceeding in case basis. The Commissioner and Secretary, Department of Industry spoke about 15 numbers of the mega project which are in pipeline and waiting to clearance from the HPC. The HPC discussed for giving VAT exemption of entry fee, taxes on imported plant and machinery, including DG set, waiver entry, tax on the plant and machinery and DG set, reimbursement of the GST, exemption or stamp duty, exemption of cost of the drawal of the from ASCB substation to the plant machinery. So, Lordship, the mega projects were, including the petitioner mega project, your Lordship approved, and tax exemption and other exemption was duly given.
Yes.
Now, the sole plea of the respondent is this, Lordship, that the land purchased by the petitioner was agricultural land, and land is in excess of the ceiling limit of 50 bighas. Regarding that, Lordship, your Lordship is pleased to peruse that para 17.
17 we have read. The Revenue Department has given a clearance. Since the last 10 years, there was no agriculture. We have read this.
So, Lordship, and when the land becomes unfit, Lordship, for the agriculture, it is treated as a fallow land or barren land, Lordship, or cultural land, Lordship, as per the provisions of the Act of 1956, Lordship. And here, the first question, pertinent question, is to consider whether the land in question was actually agricultural land, and before declaring the ceiling surplus land, whether the ADC or circle officer or DC collector, Lordship, had obtained any report regarding the status of the land. That is mandatory under the Act of 1956, Lordship. I will place those relevant sections.
Now, you have said that under Rule 22, a draft statement is required from the owner.
Yes.
That you have.
Owner, yes, from the owner, and if the owner fails to file a draft statement, but here, Lordship, we could not file because no notice was given.
And after draft statement, a hearing is done.
Hearing is
followed by a final statement.
No. Lordship, no notice was given by.
No, that is the procedure. You said that the procedure has not been followed.
The procedure has not been followed, Lordship. Apart from that, your Lordship, from the annexures, your Lordship will come to know that surprisingly, the Principal Secretary of the Revenue Department was present in all the meetings, and all the DC of the state, all the circle officers, Lordship, were directed that for mega project, even if that is agricultural land, you sumo to convert the land from agriculture to industrial or commercial, Lordship. Now I am coming to those. Lordship, the petitioner had made expenditure of more than 10 CR, Lordship, that document I have filed, purchasing the machinery, the parts, everything, Lordship. Because I had a petitioner has received the clearance from all the departments, Lord. Now, Lordship, may be pleased to come to page 75 and Act 16.
75?
5, Lord.
That is the Gaon Panchayat, no objection.
No objection, and plus your lordship, it is clearly mentioned here.
What is mentioned?
Mentioned in the line next. Your lordship may come to page, next page, 76.
70?
6 lordship, annexure 16A.
Yes.
Your lordship, here the Tapatoli Gaon Panchayat. President has given clearly mentioned at the bottom. Aru Uprakt Jami.
We have seen this. There is no
There is
cultivation.
no agriculture.
No
So
agriculture.
if there is no agriculture lordship, and all these documents were filed by the petitioners before the authority, Your Honor, while submitting his so-called reply lordship, but nothing has been considered.
Yes.
Your lordship may come to page 78.
Yes.
This is the letter, lordship, certificate of registration. Topsub India Limited, so-and-so, Demoria Kamrup is hereby registered under the Central Capital Investment Subsidy Scheme, Central Scheme, Comprehensive Industry Scheme, so-and-so, common registration under allotted to, and all these schemes is DICCK and this and that, lordship. And this was, lordship will be given to copies to all concerned. Then lordship may come to page 79. This is the letter acknowledgement by the Government of India, Commerce and Industry Department. Lordship. Falling under NIC, broad description, manufacturing of Portland cement, aluminum cement, slag cement, and similar hydraulic cement, except in the form of clinkers, proposed capacity. This acknowledgement subjected to the provisions of the press note number 7 dated note number 17 dated 28 November 97 regarding the sign implication and the legal status of the filing of the industrial entrepreneur memo. Then lordship may come to this page lordship 80. This is also by the Government of India, Ministry of Environment and Forest. Environmental clearance was given by the Environment and Forest of the central government, lordship, to the petitioners. Then lordship. Lordship, may please to come page 85, annexure 20. This is the letter from the Joint Secretary, Government of Assam, Industry and Commerce, to the Director of the Petitioner, lordship. With reference to your application, with reference to dated so-and-so, I am directed to inform you that your project at village number 3, Ujari Gaon, P.O. Khetri, Moja, Demoria, Kamrup has been given mega project assessor, and the High Power Committee is pleased to offer you the following incentive. So, lordship, tax regulation, entry fee, GST exemption were all given to the petitioner by the Government of Assam.
Yes.
Next, your lordship. Page 86 is lordship, the technology economic feasibility report, lordship, project report.
Yes.
I am skipping this. Then your lordship. Lordship, will please to come to page 208. You want to see 208? Lordship, this is the letter from the company, your lordship, to the Commissioner and Secretary, Government of Assam, Industry and Commerce Department, prayer for according permission for the proposal of Topsem India Limited, a mega project, lordship. And I am skipping this. Then Lordship may come to page 210. This is the letter given by the Industries and Commerce Department regarding the giving a special incentives to the petitioner lordship. This portion I am explaining. Then lordship may come to page 211, Annex 24. This is also a letter dated 7/5/2010, lordship, by the
Page
In the-
211.
11/21.
Yes.
Lordship got it?
Yes.
This is the letter, lordship, dated 7 May 2010 by the Government of Assam, Department of Industries and Commerce Department, lordship. And this was issued by the Joint Secretary
This
of the
is
Industry
only
Department.
forwarding the minutes of meeting
Minutes of meeting. yes.
held on 11/2/2010.
Yes, yes. Next page, next page. Page 212, lordship. Annex 25.
Yes.
Minutes of meeting. This is important document. Members present at the annex area, Shri Tarun Gogoi, Honorable Chief Minister, presided over the meeting. At the start of the meeting, the Minister in Industry and Commerce gave
But the
overview.
high-powered committee, what the high-powered committee would do, this we have seen. This is a
was-
general decision taken.
Taken and the project, mega projects were approved, lordship.
Yes.
Lordship here. Lordship, me please to peruse this line, 1, 2, 3, 4, 5. Granted to the Calcom Cement India Limited, also referred and discussed. The minister placed before the house to grant the incentive to the 3 mega cements in similar line to Calcom Cement, to the Calcom Cement India Limited. A list of the investment in the private sector till date in the state place, it was shown that there is not a single investment of the by the private sector for more than rupees 100 crore. He also placed a list of the proposal which are in hand of the industry department where investment of more than rupees 100 crore are expected. The investment value is more than rupees 5,500 crore. Therefore, the Chief Minister Assam asked Mr. Ravi Kapoor, IS Commissioner and Secretary, Industries and Commerce Department, Member Secretary of the High Power Committee, to begin the proceeding on cases to cases basis. As directed, Commissioner and Secretary briefly spoke about 15 numbers of the mega project which are in pipeline and waiting for clearance from the High Power Committee. Therefore, the Member Secretary placed the agenda item for discussion and decision by the High Power Committee.
Yes.
That's it. Next page, page 213. This next page, lordship, whatever benefit tax exemption will be given, lordship. Then lordship may come to at the bottom where arrow sign is given there. The issue of the unit being at Sonapur was raised by
No,
the.
your discussion is at page 214. That is 213 is not your discussion. 214 is CCL, 214 is TOPSEM.
Yes.
Come to 214, please.
214, lordship, the name of the TOPSEM.
Yes, TOPSEM. This is your.
Yes. So, your lordship, me please to consider, lordship,
Hmm.
other mega projects, industries, lordship, they had also purchased the agriculture land, lordship. Their lands were and they are allowed to establish. And here only in case of this present company, lordship, the discrimination has been done, lordship. And when the High Power Committee, lordship, headed by the Honorable Chief Minister, Principal Secretary of the Revenue Department also attended the meeting how the DC or ADC will declare the ceiling? They are the highest authority, Lords. They can take any decision. Then Lordship may come to page, Lordship 219. This is the government gazette notification, Lord, which is dated 8th of December 2010, Lordship. Next, second notification, Your Lordship, may please to take up. FTX number in exercise the power inferred by Section 3 of Section 6 of the Assam Anti-Tax Act, the Governor of Assam, having considered it necessary in the public interest to do so, it is hereby pleased to exempt the Topsem India Limited for its proposal project Ajadigaon Moja, the Dimoria Sonapur district, and Kamrup from the liability to pay entry tax in respect of the plants and machinery and DG said for a period of 3 years on and from this and that. So, Lordship, even then, Lordship, the next page, this is very important, vital document, Lordship. Page
220.
220.
Yes.
Annexure 27. This is the office memorandum, Lordship, by the Additional Chief Secretary, Assam Revenue and the Disaster Management Department, Lordship. Memorandum is dated. Sorry. Dated, Lordship, 5/8/13. In the interest of the public service and with a view to promote industrial activities in the state, government decide that the land which have been recorded as agriculture land but not cultivated for last 10 years more may be transferred. Including any way of purchase from private pattadars for non-agriculture purpose after reclassification by the deputy commissioner, as per the usual procedure for setting up mega project as identified, declared by the Industry and Commerce Department. However, as regard earth filling of the low-lying area, if any allotted settle lease to such mega project or purchased by such mega project will be subjected to approval of the Water Resources Department to ensure proper drainage facility and also subject to the necessary environmental clearance as per rules from the Pollution Control Board. Lordship may be pleased to come to the bottom. This office memorandum was forwarded by serial number 6 to the Deputy Commissioners, all district commissioners of the state, Lordship, of all the districts, all ADCs, Lordship. And they were having full knowledge and information, Lordship, that regarding this memorandum of the issued by the Additional Chief Secretary, Assam, Revenue and Disaster Management. Does it mean, Lordship, that the ADC or DC will supersede the orders or the memorandum, Lordship, or the resolutions of the High Power Committee? They are above the Principal Secretary or Additional Chief Secretary of the Land Revenue Department. Then, Lordship, may come to next page, 221. This is also another office paper. Dated page 221, Annexure 28. Subject is, Lordship, this is dated 17th June 14. Subject, transfer of land recorded as agriculture class but unfit for agriculture activities or where there are no agricultural activities for establishment of the industry, educational institutions, health institution, housing, etc. It has come to the notice of the state government. There are a large number of plots of land which are recorded as agricultural land, but in actual practice, they are not fit for the agriculture or has not been cultivated for 10 years or more, with a view to ensure optimum utilization of such land and to promote non-agriculture activities like setting up of the industry, education institution, health,
Health institutions.
health institution, housing, etc., which play a pivotal role in the growth and the development of the state, including the creation of the employment opportunity. The state government have decided to allow Deputy Commissioner to give NOC for transfer of such land, which are recorded as agriculture, but which are not fit for agricultural purpose, or where there is no agriculture active for last 10 years, or more after reclassification of the such plots of land. Such land will be reclassified as barren, uncultural, cultural waste as per the actual status of the land in the field. The state government has already extended the benefit to the mega projects as identified, declared by Industries and Commerce Department as per state industrial policy. Point 1, that the Deputy Commissioner will issue NOC on recommendation of the committee constituted for that purpose based on quantities of the land as mentioned below. The committee will decide regarding transfer based on detailed field verification report, including videography, photography of the land where it is felt necessary. The committee may take a field verification itself. Point number 2. It is further come to the notice of the state government in many cases that the present land owners of the land have not been able to utilize the land of non-agriculture activities like setting up industries, educational institution, health institution, housing, etc., or
These we have read.
Yes,
We have read a committee may be constituted headed by the Deputy Commissioner for giving NOC for reclassification. We have read
But
this.
in other cases, on other industrialist lordship or other units, mega project lordship, not except this petitioner, not a single sealing proceeding has been started against the other industrial lordship. And just here, last, I may be allowed to place this point number 3, lordship.
Yes, 3 we have seen. We have read
Oh, your lordship.
for
And then-
reclassification.
Then, now, your lordship, may we come to the next page. This direction has been also not followed by the deputy collector. Lordship may come to page 222, divisional committee for land above 10 bighas and up to 50 bighas. Then lordship, commissioner of the division, then lordship may come to C, government level committee for land 50 bighas above, additional chief secretary lordship.
Yes.
So this lordship, a committee was bound to decide lordship. The matter would have been referred to the said committee. Without doing all these things, lordship, the ADC declared the sealing surplus land, violating all these guidelines and the memorandum issued by the highest authority, revenue authority, lordship. This letter was also forwarded to the DC lordship. At the bottom of your lordship will find. Then your lordship may be pleased to come to page 223, annexed pension.
Yes.
Lordship, this is the minutes of the discussion held in the office chamber of the Additional Chief Secretary Revenue, DM Disaster Management on the matter of reclassification of the agricultural land, lordship. So and so officials' names are given, lordship. While welcoming the official attending the discussion, Additional Chief Secretary Revenue and Disaster Management requested the DC Kamrup to indicate the issue for decision and reclassification as well. The DC Kamrup mentioned that 3 issues are seeking government guidelines. regarding process of the reclassification of the agricultural land with reference to memo number so and so dated 5/8/13. Regarding the point number 2, regarding the process for reclassification of the agricultural land already transferred to farm company for establishment of the mega industrial project. So already, Lordship, the petitioner has purchased the land in 2008. Then point number, the Assam Fixation on Land Holding Act hindering implementation of the said government MO dated 5/8/13 in case the area quantum of like exceed the ceiling limit of 50 biga, and after threadbare discussion, these issues and in view of the relevant provisions, stipulation of the Act and rules, the Assam Land Revenue Reassessment Act 1936 as amended, Assam Land Records Manual following decisions were arrived at. The reclassification of the land is to be proceeded strictly as per the provisions of Rules 59 of the Assam Land Revenue Manual. The parcel of the land in case of the land proposed by the DC Kamrup for transfer in favor of NB Distillery Breweries Private Limited reported to have been utilized for last 15 years may be reclassified as cultivable waste as per Rule 59 of the Assam Land Records Manual. Lordship, my humble submission in this, the point number Roman 1, Lordship, one distillery company, your Lordship, he has established his factory 15 years back. He manufacturing started. That factory was also over the agricultural land. No action was taken under the Act of 56, Lordship. However, the DC is to satisfied about the current status of the land based on report from the circle officer as well as land revenue staff as stipulated in the Assam Land Records Manual or on petition from Pattadas and inquiry report of CO NLRA staff thereupon before the reclassification is ordered. Then Roman 2 lot. Regarding reclassification of the land already in possession of the firm company, DC may.
Mr. Mazumdar, you have this page 223. The last part is written by hand. Point number 3 would be very important.
Yes.
Yes.
I have just now read.
Do you have the copy, better copy? Because these are handwritten.
I also have a posted copy.
No, you have a same copy which we are holding.
Yes.
Copy of the writ petition. Do you have this separately?
No, man.
Because 3 would be very relevant, Mr. Roy.
Yes.
The Assam fixation of ceiling of land. That is the.
Yes.
Yes. Please read 3. These are handwritten. Why you don't have the.
No,
type
Lordship,
copy?
it was Lordship type copy. No, this was we received the Lordship from the government Lordship. It can be verified Lordship. It is correct. Nothing.
No, that we are not doubting that, but you should give you should have given a type copy. Nonetheless, please read the number 3.
Yes.
The Assam fixation of ceiling.
Yes. Regarding, the Assam fixation of land holding act to be.
You have given a type copy at 226, but that is also not complete. At 226, the Assam fixation of ceiling and land holding act is to be so and so. What followed? Exemplary. Oh, what is this, Mr. Mazumdar?
I can read my para 3.
No. What is this expression?
Yes.
Assam fixation of ceiling on land holding act to be.
Which para your Lordship is referring
Last, para 3.
Yes.
Roman
Assam
3.
fixation of ceiling on land holdings act
To be.
is to be scrupulously followed in case of agriculture.
Oh, this is scrupulous. Okay. In the type,
Possibly.
type portion at 226, that word is missing.
Yes.
226 is the type copy. Number 3
Yes.
is to be dashed.
Yes. Could not decipher.
Yeah,
And next sentence says, however, the option of reclassification of land remain open to DC as provided under the
As provided.
under the
No, as provided under rule.
They never mentioned.
The rule mentioned above. That is
Yes, yes, ma'am, yes, under rule mentioned above.
Next page, Lordship. Page
under.
in the affidavit of opposition filed by the respondent Lordship, no objection has been taken. They have actually admitted.
But what about this? That the Assam Fixation of Ceiling of Land Holding Act to be scrupulously followed.
Yes.
That part is there, that caveat is still there. As late as in a meeting of 2nd of September 2013.
Not is strictly to be followed, Lordship, but the also next, Lordship, please to come to next page.
Yes.
Roman 4.
Yes.
It was clarified that under normal circumstances, also the DC can take up reclassification of the land based on actual use, present a status of the land as per the rule 2359 and 109 of Assam Land Revenue Manual. In fact, this should be a continuous process in the field. Therefore, the DC was advised that he can also take up reclassification of the land other than those covered by MEWA project as per aforesaid provision based on report of the circle officer, LR staff of the revenue circle, or on application from the pattadar, and after the report the circle officer and revenue staff thereupon, and after being satisfied, Lordship. So here in the Lordship, before the issuance of the declaration of the ceiling surplus land, Lordship, nothing was done. The status of the land was not obtained. What is the current status of the land, Lordship? And on the perusal of the office memorandum, Lordship, a duty was casted on the revenue authorities, that is the DC or ADC, to reclassify the agricultural land for industrial purpose, Lordship. For industrial purpose. Nothing was done.
Mega projects were excluded other than those private.
Then
Yes.
Yes, Lordship, may please to come to page 225.
225.
225.
225.
Next page, next
Yes,
page.
next page.
Minutes of the discussion held in the office
No,
chamber.
this is the same type, it's a type copy.
Yes, yes.
325 we have already read.
Yes, yes.
These are type copies.
Now your Lordship may come to page 227. This is the notice, Lordship, issued by the ADC to the circle officer, dated 5/10/14. Notice under Rule 21 of the Assam Fixation Act 1956 with reference to above, I am directed to enclose herewith a notice under Rule 21 of the Assam Fixation of Ceiling on Land Holdings Act and requested to cause service to enclose notice and submit a service report to the undersigned within 3 days from the date of receipt of this letter, Lordship. Then, Lordship, may come to page 228. This is the letter issued by the District Commissioner, Lordship, dated 3/6/13 to the Additional Chief Secretary, Revenue Department. This is regarding a report purchase of land by NB Distillery and Beverage. Already I referred before your Lordship. With reference to subject cited above, I have the honor to furnish the details. Report relating to purchase of the land by MS NB Distillery and Beverage Private Limited as desired from you end. The government of Assam in the Revenue Department by Gazette notification this and that remitted the stamp duties chargeable under Indian Stamp Act to MSNB Distillery and Beverage Private Limited in respect of transfer of the land measuring 141 bighas, 4 katas, 11 lachas under village Vijaynagar, Rampur Moja in the Kamrup district, amounting to rupees so and so for setting up a mega project of grain, molasses and distillery. When MS Distilleries and Brewery Private Limited applied for issue of the NOC for transfer of the land, same could not be issued as the land under reference is agriculture in class, in view of the restrictions on the transfer of the agricultural land for non-agricultural purpose. Accordingly, the instruction regarding issue of NOC in contravention of existing rules, policies of the government was sought from the government by letter number so and so dated 30th 8 August 12. The instruction was received by letter number so and so dated 29 October 12, stating that decision to be taken on the matter as per the rules by the Deputy Commissioner, taking into consideration similar situated cases. In compliance with the direction of the government by letter number so and so, the NOC was approved for land transfer for agricultural purpose, only taking into consideration similarly situated cases, your lordship. It was given, lordship, for transfer of the agricultural land without doing the reclassification from agriculture to industrial or commercial, lordship. It may be mentioned that Honorable MNA 15 numbers of Palasbar LSC has submitted a petition to the Chief Secretary Assam objecting to the establishment of industry, enclosed moreover exemption of the stamp duty from the less portions are not so relevant, lordship. So, see the lordship how the state authority acting in a discriminatory matter as per whims and caprices. Then lordship may come to page 229. Lordship, this is the letter dated 8/8/25 issued by the DC Amingaon, lordship, in respect of the other industries, lordship. With reference to the subjected, I am directed to inform you that the Deputy Commissioner has approved the proposal of reclassification of the land measuring so and so as mentioned in K form, bearing pattern number so and so as per letter from the government Assam Revenue Department Management Department by letter number so and so. Thanking you, requested to correct the land records. Therefore, you are requested to correct the land records accordingly, your lordship. In the case of this other industry, lordship, it was allowed. Lordship, actually, the story started from the agitation launched by Mr. Akhil Gogoi, lordship. He was opposing for the establishment of the mega project, lordship. He has 3 times attacked the MD and the directors of the company, lordship, in their residential houses. So from page 230, lordship, we have the petitioners and their officers has lodged several complaints. From 230, page 32, 32, last page, lordship, 242. 2, lordship, are the FIR against Akhil Gogoi and his associates. Then, lordship, just to stop the agitation which was launched by the by Sri Akhil Gogoi, lordship, this land was declared as sealing surplus. Now, I would like to place before lordship, your lordship has already perused the document, lordship, which says that there is no agriculture practice since last 10 years. And there are government office memorandums, orders that the land whereupon the agriculture practice is going on since last year, it will be treated as fallow land or barren land or cultivable land, lordship. So now whether in the present case, whether the land in question, because lordship, the provisions of the section 9056 are mandatory, lordship. First question before the authority will be whether it is agricultural land or not. And that your lordship will be pleased to peruse the section 3F. Yes,
Land.
Land. Land means land which is or may be utilized for agriculture purpose or purposes subservient thereto, and include the sites of the building apartment to such land, and also includes land which is or may be utilized for the quarrying stones. So, Lordship, this because what my submission in this, Lordship, what is the purpose of the enactment of the Act of 1956? If selling surplus land is found, Lordship, it is to be settled with the actual cultivator. That is the main aims and objectives of the Act of 1956. Here, Lordship, the land was not. When your Lordship may please to come to this section 3J, Lordship. 3J. 3J, Lordship, defines person, includes an individual, a family, a joint family, a trustee, a company, body corporate, a partnership firm, and society or an association of individual, whether incorporated or not. My humble submission is this, Lordship. In case of a partnership, Lordship, there are judgments on this point, Lordship. In case of a partnership, all partners will be entitled to have 50 acres of land. All partners. Here there are 9 partners, your Lordship. I have placed that document when the LLP was formed. There are 9 partners. So all will be entitled to get 50 acres, Lordship, equal. This was also not looked into and not followed, Lordship.
What is the judgment?
Lordship,
That each of the partners will be entitled to hold 50 bighas.
section 3. I may be allowed to place later.
Yes, please, that.
Yes, I'll do. I have come. Then, Lordship, may come to section 4.
Section
4.
4, yes.
Here, Lordship, the ceiling limit is 50 bighas, but Lordship, apart from that, plus 4 bighas. So, one individual or one family can have 50 bighas for plus 4 bighas, Lordship. That is the ceiling on existing holding.
No, 4 bigha will not come automatically. There is a proviso.
Proviso.
Please read the proviso. Please read the proviso. Provided
that where the person holds orchard land,
it has to be orchard land.
Land aforesaid shall be increased by actual area of the orchard. Lordship, when there will be a mega project, orchard, garden, playhouse, everything is there, Lordship. Otherwise, the project will not be improved. But this aspect, there is no whisper, Lordship. Nothing, a simple notice has been given that you are having surplus land. Now, no patta number, no dag number, what are there?
That is a different.
Yes.
That is a different leg of argument. We will consider that. We'll consider it.
Then, Lordship.
But if you read section 4 again, which you have just now, is it limited to agricultural land?
Because this act itself deals with the agricultural land, not with any other land.
Let us see. What is the objective?
Yes,
what is the preamble?
Yes, the preamble.
Please read the preamble. Yes. Whereas it is
deemed necessary to make provision for imposition of the limits on the amount of land that may be held by person, it is hereby enacted.
And what is the ceiling on holding at section 4? Notwithstanding anything to the contrary in any law, custom, agreement, no person shall be entitled to hold as owner or tenant or mortgage in possession of land which exceeds the limit of 50 bighas in the aggregate, and the limit of 50 bighas shall be applicable to the aggregate of the land held individually by the members or jointly by some of the members.
Hmm.
So where is the qualification that it has to be agricultural land?
Because Lordship, there are, yeah. There are judgments, Lord. Our High Court judgment is. There are judgment. Judgment. Citation there. Yeah. AIR 73 Guwahati 13.
AIR?
AIR 1973 Guwahati 131 division bench. I am having the judgment.
131.
13 division bench.
Please give the name.
Names, Lordship, are Bordua Tea and Timber Company
Yes.
versus SDO Guwahati.
Yes.
Lordship may come to the para 3 of the judgment, Lord. We
Yes.
find from Annexure 3 the counter affidavit that the petitioner did not submit any return under the Sealing Act, and therefore a draft statement was prepared under Section 6 of the Act. We are concerned with the free sample grant of the key state, which contains an area of so-and-so and odd bigas, out of which the area considered as excess is so much. This land is described in the return as having salt trees, agricultural land, and deep forest. It is not, however, shown in the return that area is covered by salt trees and deep forest, and what particulars are area is covered by the agricultural land. It appears that when the same was served on the petitioner lodged objection under Section 7. To object before the collector, who passed his order on 5967, rejecting the objection petition. Being agreed by the decision of the collector, the petitioner appealed to the state government on 30th/168. Meanwhile, it is pointed out by the Mr. Singh appearing on behalf of the respondent that the final statement was prepared and signed on 4/10/67, and there was an order to serve copies of the same. It is not known whether the copies were served on the petitioner or not. At any rate, the order sheet dated 8/1/68 shows that the final settlement was duly published. Be that it may be, earlier there was an appeal before the state government which was entertained and was disposed of by the impugned order dated 6/9/69. Mr. Chaudhary has now practically given a go-by to the plea raised in the original application. He draws our attention to a supplementary petition filed on Rachna, and the court ordered it to be kept with the record after serving copies of the same on the respondent. It is only after the service of
Okay, we have read this.
So, Lordship, the sole purpose of the act is only that no land should remain, Lordship, without doing agriculture practice. But if it is not, and the ceilings are, excess land is declared with a view to acquire it and settle with the actual agriculture. There are catena of decisions, Lordship. And next. Lordship, another, our High Court judgment is, Lordship, 1993, 2 GLR. 2 GLR, Lordship, page 135. Lordship may come to para 9, last thing. Para 9. A division bench of this court in Bordua, which already I have placed before the Lordship, held in respect of the act that the very foundation for jurisdiction to acquire land under the act is that the subject matter of the acquisition must be the land as defined in section 3F of the act, and as the object is to make a surplus land available for settlement for cultivation. The object would not be achieved if the land thought to be acquired was not a cultivable one, like deep forest or sal plantation according to division bench. Any order of acquisition passed without consideration of the above fact is without jurisdiction. Similar is the facts in the present case law. In view of the para 11 last part. In the result, the petition is allowed and the rule is made absolute. Petitioners are directed to approach the state government under section 7 of the act within a period of 2 months. It is needless to say that if the above petition is filed even beyond time, the period of limitation will be deemed to have been condoned by this court and the petitioner shall be accepted. The pending proceeding before the collector shall be called for and the revision shall be disposed of accordingly. Then lordship the other, you cite the other. Okay. Yeah. Yeah.
Not cultivated for 3 years.
Yeah. This is a very short judgment. Lordship may come to the regarding it has discussed the fellow land lordship. Para 2. Para 2 lordship. We are of the view that just because the land was under occupation of the unauthorized occupant, it can be said that the land was it cannot be said that the land was fellow. In as much age, our expression to section 12 of the aforesaid act could be regarded as follow when it is not cultivated for 3 consecutive years. There is nothing on the record to show if the unauthorized occupants had kept the land fallow. Merely because the land was under unauthorized occupation, it cannot be held that the land was kept fallow. This, according to us, an apparent error of law was committed by the authorities in holding that the land under the occupation of the unauthorized was fallow land. We are not ordering further existed in 97 cannot be ascertained now. And so we direct the respondent to treat the aforesaid land as non-full fellow. So, what will we have? Huh? एक था ना ये रखो. Then your lordship may please to come. We at the 56. Lordship may please to come to section 5 of the act. Section 5 deals with lordship the submission of the return by the person holding land in excess of the ceiling. Lordship, as per the provisions of the act, it is the duty of the authority lordship who was going to declare the ceiling surplus land to issue a notice to the actual owner. Here in the present case, owner is the LLP. There is no notice in the name of the LLP. So, submission of section 5 provides the submission of return by persons holding land in excess of ceiling. Any person who, on the date of commencement of the act, holds as owner on the date of the commencement of the act. Lordship, I am laying emphasis on the words owner. Here, owner has not, till date, no notice has been issued to the actual owner, Lordship. owner or tenant lands which is in the aggregate exceeds the limit fixed under section 4 above shall within the prescribed period submit to the collector a return giving the particulars of all lands in a prescribed form and stating therein his selection of plot or plots of land not exceeding in the aggregate.
This
the-
submission of returns is pursuant to a notice.
Yes. Yes, Lordship.
Where is,
Because
where is the,
how a person
no,
will-
where is the provision of the notice?
Well, notice is there, Lordship. Lordship, may we please to come to section 7(2).
Seven?
Within bracket 2. Seven deals on the basis of the information given in the return under section 5, which shall be duly verified through such agency or as may be decided by the government, or the information obtained by the collector under section 6 above. The collector shall prepare a draft statement showing among other particulars the total area of the land held by such persons, the specific plots selected for retention and retention with them, and also the land in excess of the limit fixed under section 4 remaining after such selection. The draft subclause 2. The draft statement shall be published in the office of the Deputy Commissioner, the Subdivisional Officer, the Circle Officer, Deputy Collector, and the Mojadar, and a copy thereof shall be served on the person or person concerning the manner prescribed. Any objection received within 15 days of the service shall be duly considered by the collector, and after giving the objection opportunity for hearing, order shall be passed. Nothing was done, Lord. No final.
No, that is not the, we are asking, we are trying to find a provision requiring issuance of a notice for submission of the returns.
Submission of the return.
Return. Because
Return-
section 5 says submission of return by person holding land in excess of the ceiling.
By the person.
Now this, once this Ceiling Act came into force of 1956, a certain limit was given that this is the limit.
Yes, sir.
Now, all persons in possession of land which is in excess is required to file a return. Now,
Return,
is
Lordship.
there a requirement for any notice?
Yes,
We are trying to
return-
find, now where is the notice?
Yes.
Because just like income tax, there is no question of any notice. I'm just
No.
trying to bring an analogy.
Lordship, the section 7(2) I have placed, Lordship. It is the
Seven?
duty of the district collector to prepare a draft.
No, draft would be on the basis of what? Draft statement would be on the basis of the information given in the return.
Return here, no notice was given to the
That is the
landowner.
that is the question.
That is the question.
No,
Here
that is the question.
When the
Mr. Roy, please have the patience. Please show us the provision where there is a provision of notice. Is there any provision of notice for submission of return? Simple question.
Yes, simple question. Then Lordship may come to the rule.
There may be, we just try, place it before us. In the rules, is there any requirement?
Yes, Lordship.
Rule 3 is there.
Yes, rule is 3 is there. Rule 3 is that the period within which the return shall be submitted by a person under section 5 of the Act shall be 3 months from the date.
Date when the rules came into force.
Yes. No, this is a rule of Lordship 1957.
Yes.
Yeah.
So once the notification are published, it becomes mandatory for all persons holding excess land to submit returns.
Lordship.
Because since you are harping,
Lordship,
since your one of the main arguments is that notice was not served on the.
not only notice was not served to the actual owner.
No, where is the provision for serving notice? Mr. Mazumdar, is there any provision
For notice.
for notice? No, for filing of returns.
Yes.
Are you
Prior
required to be
notice.
notified?
No.
That is what we're asking.
There is a provision, Lordship.
There may be, kindly show it to us.
Hmm.
Because section 5 simply says the submission of return by person holding land in excess of the ceiling. Any person who on the date of the commencement of the act holds as owner is required to file returns.
Lordship, maybe please to come to section 7, Lord. Sorry, section 7.
7, yes.
The 7. Already I have played, but just
7 we have read. 7 is not on notice.
not notice, Lordship, but if suppose the provisions of the act is this, Lordship, if the landowner does not submit any statement showing the how much land he is holding, in that case, it is the duty of the revenue authority, Lordship, to prepare a draft statement and then final statement. And both should be served to the actual landowner and it should be published in the Assam Gazette, Lordship. Those are the provisions here. Suppose, Lordship, I am assuming but not admitting, because here in the present case, Lordship, the actual landowner has not been given any notice till date, Lordship. So the question of filing draft statement by the actual landowner does not arise. Because till date, no notice has been served to the actual owner. Your Lordship is fully aware that a company functions through, or a LLP firm functions through its partners or directors, Lordship. An individual director cannot take any decision, Lordship, until and unless the board of directors, as per section 179 of the Companies Act, takes a resolution, Lordship. Here the notice has been issued only 4 lines notice, Lordship, in the name of one of the partners, Lordship, Bajrang Lohia. Whether it can be treated as a notice, Lordship, because actual owner is the LLP. So if there is no notice, Lordship, to the actual owner, that is the LLP, partnership firm, Lordship, the entire declaration of the ceiling surplus is nullity in the eye of law. Because notice should be served only to the actual owner. Or any action should be taken against the actual owner.
Now let us come to, there are two, which from the statute, it appears that when the statute was enacted in 1956, it was mainly for persons who were in excess of land. Now there is also a provision in section 20 that if you subsequently acquire land,
Yes.
what will happen? Come to page, section 20.
Yes, section 20 is there. Future acquisition by
Ceiling on future acquisition by transfer. Notwithstanding anything to the contrary, in any law uses, contract or agreement from and after the commencement of this act. So this is a non-obstante clause. No person as owner or tenant or mortgagee in possession shall acquire or possess by transfer, exchange, lease, agreement or settlement any land which or without the lands already held by him or any member of the family shall in the aggregate exceed the limit under section 4. So this is for future acquisition.
For future, Lordship, but here, your Lordship, again, my submission will be that the actual, no action has been taken against the actual owner. How it will be binding upon the LLP, Lordship, or company? It cannot be. That is the crux of the matter. And even, Lordship, after filing the writ, the writ is pending since 2014, Lordship. They had not, the respondent.
How do you overcome section 21?
Penalty for contravention of section 20. The right title interest.
No right, title and interest shall accrue in favor of a transferee in any land excess of the limit fixed under section 4.
By virtue of any transaction made in the contravention. That is correct. But here, Lordship, actual owner is not before your Lordship.
No, that is okay, but it says 21 has to be read with 20. 20 starts with a non-obstante clause that if you acquire land subsequent to the statute, which is in excess of section 4.
Lordship, already I have placed the document before your Lordship that the highest authority of the Revenue Department, including the Chief Minister, Lordship.
No, that is on a different context. That is on the viability of the company. We are on the land aspect. You may be correct in contending that this aspect was very much before them and they had raised no objection on the land.
Yes, yes.
They could have.
Yes.
That whether it is within the ceiling. That question has never arisen or considered by the High Powered Committee. It was only on the viability, environmental clearance, other clearance.
Apart from that, Lordship, those documents of the are of the earlier time, because the sealing process was started in 2014. After 2014, Lordship, my mega status was granted by the government, Lordship, before that. Before that, Lordship. So all the revenue authorities or other government officials, they had full knowledge and information that the LLP company is having the honor and the mega project status has been given, all clearance has been given, Lordship. And in case of Lordship, the funniest thing is this. In case of the similarly situated company, Lordship, the permission was given. No sealing proceeding was, why they were spared, Lordship? Why? Whether this is not the naked violation of the Article 14, 15, 16, 21 of the Constitution. Definitely not. And those things are not recorded. And in the affidavit in opposition, Lordship, not a single document has been annexed by the respondent. And no averments have been denied. Simply, the affidavit in opposition shows that it is agricultural land and the land has been declared access as per the provisions of the Act of 1956. That is their simple affidavit. And even the government, Lordship, did not file the affidavit in opposition more than 10 years. Then this Honorable Court imposed a cost of rupees 50,000 against the district collector, which they had paid. So, Lordship, when the discrimination is writ large on the face of the record, Lordship, whether in my humble opinion, this is a fit case to be interfered, Lordship. And already, Lordship, when the land has been held that it is not fit for cultivation, Lordship, already I have submitted before Lordship that as per the provisions of the Act, Lordship, I am judgment. And this Lordship, already I have submitted before Lordship the decision of the 1973 AIR Guwahati 131 Division Bench, which has clearly shows.
Bordeaux.
Yeah. Clearly let down the law that if it is not agricultural land, it cannot be declared in sealing surplus law. And there are catenan decisions, Lordship. I may be allowed to, after taking the xeroscopy of the citations, Lordship, which runs into more than 40 pages.
You did not give the entire thing. You just give the first page and those pages containing the paragraphs which you would rely upon. We'll take out the decision. Madam, only the first page and those pages having the paragraph which you would be relying.
In all the judgments, Lordship, even EPSCO judgment is also there. It has been held that if the land is not agriculture or unfit due to any other reason, the provisions of the Act of 1956 cannot be, no action can be taken under this Act. And Lordship, here, when the 1956 Act came into force, Lordship, Assam was a pure agricultural list land lordship. Now it is a days of industries lordship. After the mega project, if the petitioners were been allowed to proceed with the construction lordship, if the sealing proceeding was not, would have been initiated against the petitioner lordship, at least indirectly or in more than 1,000 citizens would have got the employment lordship. Because already your lordship has seen that the high powered committee observed that there is not a single mega project company has come in Assam, not a single. And when this all tax exemption, everything facilities were given lordship, the others are enjoying only the petitioner. That is a very solid ground lordship. The other similarly situated industries, they were given the agricultural land, they have established their factory, they are producing they are selling their products. Why only in case of the petitioner only he has been selected lordship? This is nothing malified intention lordship. And suppose lordship if the sealing proceeding is taken, what prevented the respondent lordship to issue the notice in the name of the actual owner and to prepare a draft final statement? Till that lordship, land has been declared sealing surplus lordship, almost 92 bighas. Till that there is no gazette notification. And the land cannot be declared, will be deemed to be a sealing surplus unless it is published in the gazette. सारा नहीं है ना। ठीक है, पढ़ के बता देगा। नहीं कल section. Seven six option 7 within the section.
Yes.
Very important provision is there, lordship. May we please to take up section 12 of the Act 56.
Okay. Yes. Principle of,
I am coming.
principle of compensation.
No, no, see, this is section 12 explanation lordship deal that provide the land which is not cultivated for 3 years immediately preceding the date of acquisition or which does not contain any tree etc. shall be regarded as fallow land. Lordship explanation, lordship section 12 subsection 3 and just subsection 3 bottom explanation. Lordship got it?
Yes.
Land which is not cultivated for 3 consecutive years immediately preceding the date of acquisition or which does not contain any tree, bamboo or thatch shall be regarded as follows. Provided that where the land is revenue free or assessed to the land revenue as a concessional rate or where it is not assessed by the land revenue under the provisions of some land and revenue regulation 8086, the compensation shall be, this is regarding. So lordship, where the section 12 explanation clearly provide that lordship after acquisition of the land lordship or not cultivated consecutively for 3 years lordship, it will be deemed to be a fallow land. There is a
That will not come into your, that is not the issue here at all.
No.
Because this section 12 is with regard to the compensation part. What lands are to be treated as fallow land, what land to be taken as agricultural land. You kindly read the section 12.
My humble submission lordship, if a land becomes fallow land lordship, it is not agricultural land.
But kindly read, it is only with regard to the aspect of compensation.
Subsequent proviso.
No, not subsequent, the first initial provision. Section 12, where any land transferred to and vested in the state government under section 4(2) of the Act, that means it is already declared ceiling, then what will happen?
Yes.
There shall be paid compensation which shall be determined by the collector or any other officer authorized by the state government in the manner in accordance with the principles laid down. Now, how do you determine the principle, the amount? So there are different amounts for different quality of land, and this fallow land comes in the explanation.
I leave it to your lordship, but
No, let us deliberate and come to a reasonable thing. 3 years condition will come only for the aspect of determining compensation. Because if you read 2 subsection 1, if he is an occupancy tenant, 10 times the full rate of annual rent revenue payable for the land, and when the land is fallow, 35 times.
That is regarding final compensation.
Yes, it is only for the purpose of compensation.
Here, lordship may be pleased to have the lordship for preparation of the draft and the final statement. Forms are given in the act. Lordship is aware. Lordship
in the rules. In the rules.
In the rules.
Yes.
Yes. And then lordship may be pleased to come to the impugned order. Page 40, Lord.
Page
40.
40. Yes.
My junior may be allowed.
Yes.
Facing difficulty.
No problem.
Peruse the inquiry report submitted by Shri B.B. Dev Chaudhary, Additional Deputy Commissioner, Kamrup Metropolitan District, regarding allegation of possessing ceiling excess land by one Shri Bajrang Lohia, Director, Topsem India Limited, measuring 147 bigha, 2 katta, 11 lechas, in 2 villages, namely Senabar and number 3 Ojari under the Moria Moza of Sonapur Circle. Also examined the registered deeds regarding the purchase of land. Peruse the report of the Circle Officer Sonapur, and it transpires that an area measuring 142 bigha, 1 katta, 4 lechas have been mutated in the name of MS Topsem India, represented by Shri Bajrang Lohia. Verified the land records pertaining to the land under reference, and it transpires that the land is agriculture by class. Also peruse the written submissions furnished by the Learned Counsel on behalf of the behalf of Shri Bajrang Loya representing MS Topsim India Limited. Considering the above facts, I, Shri M. So-and-so IS District Collector, Kamrup Metropolitan District, is satisfied that MS Topsim India Limited, represented by Shri Bajrang Loya as Director, has contravened the provisions of Section 20, subsection 1 of the Assam Fixation of Ceiling on Landholding Act 1956, which reads, notwithstanding anything to the contrary in any law, usages, contract, or agreement formed and after the commencement of this act, no person as owner on or tenant or mortgagee in possession shall acquire or possess by transfer, exchange, lease agreement, or settlement in any land or without the land held with him and any member of his family shall in the aggregate exceed the limit fixed under the Section 4 of this Act. The penalty for contravention of Section 20 is clearly mentioned under Section 121, which reads as, no right, title, and interest shall accrue in favor of the transferee in any land in excess of the limit fixed under Section 4 of this Act by virtue of any transaction made in contravention of Section 20 above. And as a penalty for such transaction, the rights and interests of the transfer or in such excess land purported to be transferred by such transaction to the transferee shall deem to be transferred by the government and in occupation of the land on his behalf or through him shall be liable to be rejected and in the manner prescribed by the collector or any other authorized in this behalf, provided that nothing in this section shall affect the liability, if any, of the transferee for the payment of consideration on such transactions. Provided further that no suit or proceeding by the transferee shall lie in any court for recovery of the consideration of any transaction. In view of the contravention of Section 20 of the said Act, I, so-and-so District Collector, pass this order under Section 21 and in accordance with Rule 21(2) of the said Act for taking possession of an area of land measuring 92 bighas, 1 katta, 4 lechas, found to be in excess of the limit fixed under Section 4 of the said Act. The circle officer, Sonapur, shall accordingly take possession of the excess land measuring 92 bighas, 1 katta, 4 lechas and correct the record as government land.
So, my lord, on a perusal of the impugned order, your lordship has come to know that nothing has been mentioned from which patta or dag number how much land will be declared a surplus. No details has been given, lordship. And how much land will be the returnable, because as per the Act of 1956, lordship, the actual landowner is entitled to have 50 bighas of land. So what will be the returnable portion? What will be the ceiling surplus land details, lordship? Nothing has been given. Such a vague order has been passed, lordship. In spite of the fact, the lordship, and your lordship, in this impugned order, it is mentioned that the Bajrang Loya is a director of the Topsim Private Limited Company. Absolutely wrong. He was never the director of the Topsim India Limited, lordship. In spite of my filing objection, your lordship, in the objection filed by me before the ADC lordship, I have clearly stated that I am not the owner. Why you have served to me? That objection again, I
Yes, we have read that objection.
Yes. So, lordship, in spite of that, the impugned order has been passed that the owner is the Topsim India Limited Company, lordship. When the LLP certificate has been given, conversion order of the from the limited company to LLP, that certificate has been given, lordship. In spite of that, lordship, the finding by the learned district collector that the land belongs to the Topsim India Limited, lordship, is absolutely illegal and beyond jurisdiction, lordship. Because actual owner was never given any notice, any information for filing any draft statement, lordship, or details of the land. In the impugned order, lordship, on what basis, lordship, the gazette notification will be issued that such and such dag number, patta number, land area, this has been declared as ceiling surplus, and how much land, and the land of 50 bighas will be the returnable portion of the landowner, lordship. Nothing. That's why till that no gazette notification has been issued, lordship. And see the lordship, the affidavit in opposition of the respondent. Lordship, may please to take up the affidavit in opposition. Para 4. How a IAS officer acts, lordship, see the intelligence. Para 4. That with regard to the statement made in para 9 of the writ petition, the deponent has said that the petitioner number 2 was a director in Topsave India Limited. The petitioner number 1 and the notice under the Assam Fixed Selling Land Act was served upon him. So the existence of the Topsave India Limited was wiped out when the it was converted into LLP in 2011. That document already I have produced. So in spite of that, lordship blatantly stating that Topsave India Limited was a company and it was served to the Bajrang Roya, that is the petitioner number 2. Absolutely incorrect averment, lordship. Then lordship, suppression of facts. Then lordship may come to para 5. That with regard to the statements made in para 10 of the writ petition, the deponent states that the impugned order dated so and so was passed by the then Deputy Commissioner Kamrup Metropolitan after due consideration of the reply dated 28/14. When what dated 28/14 is my objection filed by Bajrang Lohia lordship, that he is not the owner. In spite of that, the correct notice was not issued, lordship, to the actual owner. And the said fact is recorded in the impugned order dated 20th/5/15. See the vagueness, your lordship, and the arbitrariness of the respondent. Then lordship may come to lordship, see paragraph, lordship 7. With regard to the statements made in paragraph 12, the writ petition, the deponent has no comment to offer. Para 12, lordship, of the writ petition deals with your lordship, may please to come to para 12 of the writ petition. That after receipt of the order dated 20th/5/15, the petitioner number 2 placed the matter before the board of partners of the petitioner number 1 for due consideration, and it was resolved to file the instant writ petition as the board of partners refused to ratify the acts of the petitioner number 2 as the land in question was purchased in the name of the Topsave India Limited, which was a limited company, and any individual director cannot act personally liable, and a company incorporated under the Companies Act functions through its board of directors and not through an individual director, and as such the board of partners passed a resolution dated 4/7/50 refusing to ratify the acts of Sri Bajrang Lohia lordship. So the company, the LLP partnership have already nullified the so-called objection filed by him, lordship. Petitioner number 2, but what is the reply in affidavit? No comment. Whether it can be treated as it is not evasive, lordship, under the law. Then lordship, may come to page 9, lordship, para 9, page para 9 of the affidavit and all. That with regard to the statements made in para 14 of the writ petition, the deponent stated that it came to the notice that the petitioners are in possession of the land in excess of permissible petitioner, lordship. Limit of 50, therefore the circle officer was directed to furnish a report in respect of the same, and so that necessary action may be taken against the petitioner for violation of provisions of the Assam Fixation of Selling Land Act 1956. Then para 10, that with regard to the statements made in para 15, the writ petition deponent has no comment. regarding this purchase of the land, Lordship, in the earlier name of the earlier company. Then Lordship may come to para 13, Lords. That with regard to the statements made in paragraph 40 of the writ petition, the deponent states that the petitioner number 2 was a director in Topsave India Limited. Absolutely incorrect. The petitioner number 1, therefore, the petitioner number 2 is LLP, Your Honor, not the company. And therefore, the notice under the Act of 1950 was served upon him. Upon him means Bajrang Lohia, petitioner number 2. Then, Lordship, para 14, that with regard to the statements made in paragraph 41, 42, 40, the writ petitioner, the deponent states that impugned order dated 25/25 was passed by the then Deputy Commissioner Kamrup is a written order which states the relevant provisions of the law that has been violated by the petitioner and has been passed after consideration of report called from the Circle Officer Sonapur. Reply by the petitioner number 2, reasonable opportunity of being heard was provided to the petitioners before passing of the petitioners. I am laying emphasis on the words petitioners, Lordship. Here petitioner number 2 is Bajrang Lohia, Lordship. So absolutely false averments have been made by an IAS officer, Lordship. Then Lordship may come to para 15, Lordship. With regard to the statements made in paragraph 44, 45, 46, and 47 of the writ petition, the deponent states that petitioners at no point of time file any return giving particulars of the land owned by them, and therefore the report was sought from the Circle Officer Sonapur, which served as draft statement under the Act and was furnished to the petitioners. But in the affidavit in opposition, Lordship, the averments made by the respondent is that the draft statement was prepared which was served to the petitioner. Nothing, Lordship, because in that petition we have denied, we never received. And surprisingly enough, there is not a single annexure. If the draft statement was prepared, what prevented the respondent for annexing it? In fact, no draft statement was prepared, Lordship. They are honest to them, and records were called, Lordship. Till date, no records have been produced before this Honorable Court, Lordship. For proper adjudication, Lordship, if the records are, if the respondents are compelled to produce the record, everything will come. The cat will come outside the bag, Lordship. Petitioner, and therefore they never demanded the same by filing any petitions to the Deputy Commissioner Metropolitan. However, the petitioner is trying to compare cases of transfer and conversion of the agricultural land with a sealing proceeding carried under the respective acts. Then, Lordship, regarding para 16, that with regard to the statements made in paragraph 48, 49, 50 of the writ petition, deponent has no. These para, Lordship, 48, 49, and 50 of the writ petition deals with the agitation launched by KMSS against the petitioner, Lordship. So there is no comment. So admitted, Lordship. Then, Lordship, para 80, that with regard to the statements made in paragraph 52 to 58 of the writ petition, deponent state that the provisions of the 1956 as regard draft statement, final statement, and choice of land to be retained is applicable in case of landholder who furnish a return under the provisions of the Act of 19. As such, the petitioners have not submitted the return under 1956 willfully and deliberately. Such option may not be absolute available to them under this Act. Lordship, the Act itself provides, Lordship, that if any landowner does not file the statement, Lordship, then it is the duty casted upon the revenue authorities to prepare a draft statement and final statement, Lordship, which has not been done. Then, Lordship, may come to para 21. That with regard to the statements made in paragraph 63 of the writ petition, deponent states that the petitioner number 2 was a director in Topsave India Limited, the petitioner number 1, and therefore the petitioner number 1 is not the Topsave India Limited, Lordship. It is the silly observations, Lordship. And therefore the petitioner number 1 entity which acts through its director bound by their act. Whether in the LLP there will be any director or absolutely not, partner under the LLP Act. Not a single document has been annexed. And without giving the patta number, dag number, area of the land, which portion will be declared as a ceiling surplus, which portion will be the portion of the land covered by patta number, dag number, will be the retainable portion 50 bighas by the actual land. Nothing is there. In the affidavit position also there is nothing, Lordship. Blatant violation of the provisions of the Act of 1956 and as well as the natural justice. Till date, the actual owner LLP partnership firm has not been served with any notice. So these were my solutions.
Yes.
Again, Lordship, I'm sorry, I am to submit. In the meantime, Lordship, in the industrial policy. OC लिखा हुआ। This is the industrial policy of the Assam Lordship 2008,
Yes.
which also provide that agricultural land should be converted, declassified. The Lordship, may please to come to page 11. Page number is given at the bottom, Lordship. Page 11. Clause 1 deals with issues relating to land. Land availability in time for industrial use as a reasonable advantage to an investor is the main concern of the government. Together with the Revenue Department, the state offers a speedy acquisition of land in order to allocate government land on the basis of the maximum advantage offered by the project land suitable for industry will be identified in each district and allotted on priority basis for industrial unit parks. So, Lordship, when my submission is this, when there was a mega project, Lordship, so it was as per the industrial policy. Suppose, Lordship, the declaration of the ceiling surplus land is as per law. Suppose, assuming, but not admitting, Lord. In that event, Your Honor, the ceiling surplus land could have been allotted or settled, Lordship, for the industry for mega project here. This issue number 1 deals with that. The present second para, the prevalent land policy of 89 highlighted that over the years, land as a resource has become scarce in both urban and rural. As per the Constitution of India, land resource management is the state subject and is dealt with by the autonomous district council areas of Karbi Anglong, North Kachar Hills and the Bodo Autonomous Council district of Kokrajhar, Chirag, Baksha and Udalguri. The subject has been transferred to the respective council. Next para. The matter of allotment, settlement of the land for a special cultivation like tea, office rubber, coffee, rubber, etc., which activities fall within the ambit of the industrialization, is governed by the provisions of the clause number 5 of the land policy, under which high land and ceiling surplus land suitable for such cultivation is identified and feasibility report is prepared for allotment settlement with the eligible entrepreneurs for a special cultivation. The maximum ceiling of allotment of land for a special cultivation is 4 hectares an individual, and the aggregate of the holdings of the number of the members in case of cooperative society, the land allotted must be utilized within 3 years, failing which it will be reverted to the government. Under clause 7.2 of the land policy for a speedy industrial development in the estate, the government may especially consider allotment or settlement of the available land suitable and for industrial purpose. To further simplify and support the cause of rapid industrialization in the estate, the new initiatives contemplated are. Next page. Streamline the procedure in respect of speedy acquisition of land by bringing statutory amendments and executive direction with special focus on land use reclassification. Allotment and settlement of the land on the basis of a real-time land use map with preferences to the entrepreneurship promoting production capacity, productivity, and employment generation. And next, identification of the land for a special economic zone, industrial park, and estate with the facility of automatic reclassification. This is very important, Lordship. The DC is bound to reclassification, Lordship, when the industry comes, Lordship. Classification on the basis of the predetermined parameter, simplification of the process for allotment, settlement, and registration thereof. Computerization of the land records and registration with integration. Use of GIS for upholding the maps and records to maintain its real time. Simplification of the valuation of the land through zoning e-registration. Adoption of PP mode and outsourcing for expedite and the transaction. Lordship, till today, in Lordship, in the near Jalukbari, Lordship, the 6-lane road. If you, I am having also a plot of land there by the side. Till date, Lordship, if Jamabandi will show, those are all commercial plot, but it will say Aldom, Nova. Nothing, no modification has been done, Lordship. When Lordship, then Lordship may be pleased to come. Lordship, may be pleased to come to page 20. At the bottom page number is given. This is the Government of Assam Industries and Commerce Department dispute, orders by the Governor of Assam. Page 20, Lordship, 20.
Of the writ petition?
This policy, yes.
Of writ petition? Page 20
No,
of
in the industrial policy,
of the industrial.
2008.
Okay.
Page 20, Lordship.
Yes.
This is the notification dated 12th of May 2009, Lordship, and irrelevant portion is Lordship, may please to come to page 26. Heading is Development of Industrial Infrastructure. Page 26, Lordship, at the bottom, page number.
Yes.
Point 5.1. Development of the quality infrastructure for industrial growth will be accorded highest priority. Government will ensure that there is at least one modern industrial estate park with all required facility in those districts of Assam where adequate potential for setting up industries exist. In addition to the private sector will be encouraged to set up industrial estate park high demand area. 5.2. Government will take necessary steps for development of the land belonging to the closed public sector undertaking through its industries and infrastructure development corporation so that they may be properly utilized for industrialization of the state. 5.3. Uninterrupted quality power supply plays a crucial role in the product. This is regarding farming. So 5.5 up to adequate and connectivity. Then your lordship may come to page 30, lordship.
3030.
Lordship.
Yes,
Re-
please. Yes, please.
Regarding tax incentives to
Yes,
the mega
yes,
projects.
we have seen this.
Exemption from 7.2, lordship, exemption from stamp
Stamp
duty
duty and
and registration
registration
fee.
fee. Yes.
These are all facilities are given to the mega projects. Then lordship may come to page 32. Heading is lordship, special incentive for mega project, clause number 8.2, lordship. To encourage the establishment of the mega project, all incentives, including priority land allotment, the ceiling amount of subsidy, and or the period of the validity of the tax concession under this policy will be relaxable on cases to case basis to be decided by the high power committee, especially constituted by the government for this purpose. High power committee document already I have placed before you. Then lordship may wish to come to your lordship may please to come to page 52.
Yes.
Lordship, it is annexure Roman 6 is your lordship. This is regarding the list of the industries and the
No,
rate
Mr.
category.
Roy, there is no dispute that cement comes under the whole project has
Yes.
been sanctioned as by the high powered committee.
Number one is lordship after aluminium, next
Yes,
serial
we
number
have seen
2 is
cement.
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 Cement lordship.
No, that is not the issue. Issue is with regard to the land.
No, land is-
Issue is regard to the action taken under section 20 and 21.
Yes. Now regarding that, the defect in the impugned order lordship as well as the.
That you have submitted.
Already I have submitted.
That is the relevant aspect. You have already made a submission. We'll hear Mr. Mazumdar at 2 o'clock. I think there is one.
I have more submissions. In the meantime, reclassification of the Land Act has.
Okay,
come.
we'll continue, but
Only that will be my last submission.
Okay,
Okay.
10 more minutes to you to wind up, and then I think we have a motion which is fixed at 2 o'clock. So immediately after the motion, Mr. Roy will complete, then Mr. Mazumdar. Mr. Mazumdar, we can just highlight what would be our questions.
My lord.
What we can just put to you are the
Yes. yes,
clarification so
Yes.
that you can also look into it.
My lord.
See, first, land has been defined, 2F. Now, if the entire Ceiling Act is confined on the definition of land under 3 to F.
3F.
And 3F. And the restrictive meaning of 3F has been explained by the division bench in Borjuar. So we cannot go anywhere else. We have to be confined to the characteristic of the land, whether it is agricultural land or can be used for agriculture. Whatever is the definition. And the other parts also, stone queries, everything. Now, there are documents to show that this land was not in occupation, or not used for agriculture purposes for the last 10 years. There are. So whether there was a declassification, we are not, though Mr. Roy is emphasizing on the aspect of how powered committee, the cement factory, our question is not that. Our question is on the impugned order, the application of the Ceiling Act. And if you proceed with the Ceiling Act, you assume that the land is within the definition of land under 3F, nothing else. It cannot be any other else.
That will be the crucial.
Crucial. So, what is the definition? What is the subsequent? And this is also subsequently acquired land. We may not be too impressed by Mr. Roy saying that 4, 5. Those are only for those persons who were in initially when the act came into being. But for subsequently acquired land,
correct. On that,
absolutely, subsequently acquired land 20 and 21 will be. He may have a valid point on the issue of notice because this is a panel provision under 21. So the aspect of giving a notice to the actual person may be there. I'm just indicating it to you, so I need your response.
I'll address on that.
Whether notice was given to the LLP, there was a change in the ownership from a private limited company to LLP. And since it has got penal provisions, principles of natural justice needs to be followed. Those are basically the questions. We may have some more.
Apart from that, Lordship, I have been denied the right to file an appeal before the state government as required under Section 7. Because appeal can be filed only
Okay,
if
we'll-
draft statement is served.
Yes, we'll come.
Bye.
Obliged.
I think. My lord, before my train starts, my lord, I want to place one thing, my lord. Morning they took time, my lord, and today at 1 PM they have gone to this. Like today is the 15th day, my lord. This is what going on, my lord. Nobody will come to court, my lord. This is the way, my lord, they are doing it. Today is the 15th day. And they have
Which matter?
that, my lord, the matter which was last time when the other side council said today that eviction matter, item number 4.
Idea, so do it.
And my lord, they went today. How could they do it, my lord? This is what they
Dinath fixed at 2 PM.
Yes.
at 1 PM they went there, my lord.
May I call him?
Now we'll hear Mr. Nath. Let us see what is happening. These are photographs of what
Yes,
time?
my lord, they have sent us through over there. Your lordship will find the time. That is 12:58 PM today.
Where is the time?
My lord, the bottom, my lord, your lordship will find 12:58 PM. 55, 56, 57, 58.
Please call Mr. Nath.
He's coming.
Because my lord, the division bench judgment, I found that notice was absolutely bad. But I'm giving this judgment of the division bench, my lord. Notice was at page 81. And the division bench, my lord, gave the direction at, my lord.
Yes.
The directions are, my lord, page 16 of total page 18, my lord. You also will find page 16 of total page 18.
Page
16. The total page are 18, 16, Roman 1.
This is Salakuddin or what?
No, my lord, after Salakuddin. After Salakuddin, this has come by division bench, my lord.
No, this is the division bench.
Division bench.
Salakuddin is also by division bench.
Division bench. After division bench, my lord, these guidelines were framed down by Justice, my lord, Justice Bishnoi and Justice Nair. And my lord, Roman 1, the respondent shall issue fresh individual notice.
Yes.
Then, my lord, to encroachers government land and has been issued asking to show cause why they should not be evicted. By taking rule 18, the respondent shall issue individual notice to the appellant alleged encroachers within period of 30 days from today. The appellants at the present two appeals are that liberty to submit individual replies to a notice to be issued by the respondent.
Now, what is your grievance? No
Madam,
individual notice was served.
No, nothing. Last order, your lordship may look into the last order of your lordship.
Of this court.
Of this court.
In this proceeding.
In this proceeding. General notice at page 81 was issued.
Notice was vague without there being any description of content. No individual notices have been served. Okay. Yes, what do you say?
Well,
anything more?
My lord, I am relying on this judgment with this procedures to be laid down.
Aurobindo.
Aurobindo.
I had some telephonic discussion with the ADC just a few minutes back. They are sending me. Till now I have not received. I'll get it. But the telephonic instruction is that those guidelines, the individual notice and schedule, those are in respect of government khas land. These are riverside land. These lands are riverfront land and the land reserved for roadside and the riverfront land. Apex Court, they said that Honorable Apex Court decision is there. According to that, this notice, individual notice.
Which is the decision of the Honorable Apex Court?
I'm just waiting that.
But Mr. Roy Choudhury is making another allegation that This matter was listed today. In the morning, you took time, and in the meantime, some dismantlation, some demolition has taken place. Yes, and he's placing some photographs. You should, at least you should wait for the decision. We do not know decision may be in your favor also. You can go ahead, but without there being a decision, we grant time on the presumption that you are on your own will maintain something.
Malad, I am awaiting that. Malad, I'll just get it, Malad. Lordship, kindly give me.
But this photographs, have a look at this photographs. He says the time is also there, 12:58 today. See, you have to go, you can carry out an eviction proceeding, but there is no restriction as such. But what is required is the following the due process of law.
That's true.
And when a matter is pending before us, you have been granted time to obtain instructions. If you, in the meantime, demolish everything, though there is no restriction as such from this court, there is no restraint order, but there is a sacrosancy of the proceeding. You place before this court the instructions, we allow you to go ahead. We have been allowing you to go ahead in all cases.
Yes.
But this amounts to a circumventing the court's process, preempting something.
No,
This is
I'm
not, this we will not take it in the right spirit.
Malad, I'll just take, kindly give me 10, 15 minutes.
After a while,
15 minutes time. Malad. I'm just talking to them.
you take instructions on this aspect also.
Lordship.
Mr. Roy Chaudhary, you take this and show it to your colleagues. একটু continue করলে একটু continue. Where is Mr. Mazumdar?
Your Lordship is coming.
You complete within 10 minutes, you complete your arguments.
My lord, I have given a copy of the Assam Agricultural Land Regulation of Reclassification and Transfer for Non-Agricultural Purpose Act 2015. Your Lordship, I would like to place only section 4. I have flagged laws. Section 4(1). Lordship got it?
Yes, section 4.
4(1), Lordship. I have, it is flagged.
4(1), yes.
Such land which is recorded as agricultural land but has been already become unfit for agriculture purpose, or where there has been no agriculture activities at least 10 years preceding the date of application for permission, shall only be classified or reclassified, transferred for intended non-agriculture purpose with the prior approval of the Deputy Commissioner. So, Lordship, when the land as defined under section 3F, and in the picture that is not agricultural land, Lordship. Already there are 2 certificates, Lordship. And so, Lordship, if it is does not cover under section 3F of the Act of 1956, it is not a agricultural land. So entire exercise was nothing but a futile exercise without jurisdiction. And the division bench judgment in Bordua Tea State, Lordship, already I have placed, where there were salt trees and other plantation lots. It was held by the division bench that it is not agricultural. Land is not covered under section 3F.
Yes, where is your AAG? Is there a different timing for him? Mr. Mazumdar, we thought you have a different timing for the court.
Sorry. In fact, I was looking into this file only.
He has placed another notification, a gazette notification of 20th of September 2015. The name of this act is Assam Agriculture Land Regulation of Reclassification and Transfer for Non-Agricultural Purpose Act 2015.
15. I'm aware of that.
That is the what.
There is some amendment of also in 2024.
So your response may have to come for this last submission.
Yes, ma'am.
Okay. Please.
Madam. Here the action under challenge is an action under section 21 of the 1956 Act.
Yes. Yes.
Now, Lordship will kindly come to the impugned order first. From there, I'll start, man.
Okay. Impugned order is page 40.
Page 40, madam. Page 40 is the impugned order.
40.
40.
Yes.
And before that, my lord, the notice to show cause was issued. Of course, it is date somehow. Date is there, but it's not legible. No. Page 29 is the notice, my lord. Lordship is in page 29, madam.
Yes.
29 notice was issued. It has been reported by the Circle Officer Sonapur that excess land measuring 92 bighas has been transferred to you in village number Swenso, Ojori and Senabori under Dimoria Moja of Sonapur Revenue Circle in contravention of section 20 of the Assam Fixation of Ceiling on Landholdings Act 1956. Accordingly, you are hereby directed to show cause as to why you should not be ejected under the provisions of section 21 from the excess land which has been transferred in contravention of section 20 and reply within 15 days. Lordship will notice here that although word to be ejected is mentioned, otherwise Act says for taking possession. Now comes the reply. Reply is of 28th of October 2014.
Yes.
Now the submission has been repeatedly made that see land does not belong to me. And in paragraph 1 and 3 of this reply also says that notice has been issued in the name of Bajrang Lohia, who is not the owner of the land measuring 92 bighas, so. And para 3, my lord, in the reply that the land in question was purchased in the name of Topsen India Limited, which was a limited company. As such, the above referred notice in the name of say Bajrang Lohia is illegal, and it is specifically replied that in a limited company, any individual director cannot be personally liable, and a company incorporated under the Companies Act functions through its board of directors and not through an individual director. And as such, the notice is absolutely illegal and not addressed to the proper person. But apart from this, the now para 4 says that, however, we are giving our reply as follows. Now, apart from these two paragraphs, my lord, in the entire reply, your lordship will find certain objections have been raised about the manner of the procedure followed in issuing this initial show cause notice. And that, like para 1 says that land measuring 147 bighas, 2 katas, 11 lechas situated in 2 revenue villages of Sonapur Circle has submitted report before your honor that the petitioner purchased the agricultural land and sale deeds were registered in the office of the so without obtaining permission or NOC, and ADC himself has clarified in his report that during the period when the sale deeds were executed to NOC no NOC was required as per the judgment of the High Court dated so and so, and the name of the petitioner company was mutated over 143 bigas, etc. My lord, these are not relevant in my humble submissions. Why I am saying, my lord, a consistent argument has been made. See, the land belongs to Topsem India Limited. In the meantime, there has been a change in the character of the organization to Topsem LLP. Partner, it's a limited liability partnership. There is an act of 2008. Under that, there has been a change. Now, if your lordship kindly turns to the sale deed, one of the sale deed annexed here is at page. Yes.
One is at page 51.
51. I am referring to page 51.
Hmm.
It's a sale deed of 10th of April 2008, my lord. From some people, the land has been purchased. In this sale deed is in respect of a part of the land, my lord. So
Yes.
there are several sales. They are mentioned in the petition somewhere that as a specimen, one sale deed they have annexed.
Yes.
Now, page 52, your lordship turns, lordship will find the sale is in favor of Messrs. Topsem India Limited, etc., etc. Then third line towards the end, here represented by Sri Bajrang Lohia.
Yes.
So it is Bajrang Lohia, petitioner number 2, who is representing the purchaser of the land. Now, if your lordship goes further to page 49, this is a copy of Kheraj Miadi Jamabandi, my lord.
49.
Page 49, my lord.
Yes.
Now, left-hand side column, lordship will find serial number 9, Messrs. Topsem India Limited, Lohia House, etc., represented by Sri Bajrang Lohia. So far as, this is what I am trying to project is, so far as the Deputy Commissioner and its office is concerned, they are concerned with the revenue record. A revenue record says the land was purchased by Topsem India Limited, correct. But then you have represented the company at the time of purchasing and even at the time of mutation. You are not saying that, see, your lordship is aware, all of us are aware that a limited company is an entity which can purchase land. But here, although the company is purchased, somehow which was not necessary under the law, that it is to be represented by one of its persons and his identity is not disclosed in the sale deed. He says it is represented. Now, there was an argument when 2-3 times I have heard that the petitioner has argued that Bajrang Lohia is not a director. He was never a director.
Yes.
My lordship will kindly, for this, my lord, possibly this is not a correct submission, your lordship kindly comes to the reply. Page 30, my lord. 30.
Yes.
Paragraph 3, that the land in question was purchased in the name of Topsem India Limited, which was limited company. As such, the above referred notice in the name of Bajrang Lohia is illegal, and it is specifically replied that in the limited company, any individual director cannot personally be liable. So he is saying he is a director.
No, that cannot be the meaning.
There is another.
That can be one of the interpretation, that cannot be the sole
I will
interpretation.
show another thing. There is another document. I will just show my lord. He himself has said that I am the director. I will come to that matter. So, lordship is saying the sale is in the name of company represented by petition number 2. Mutation is in the, lordship kindly see page 49 at the bottom. The note is there.
Yes.
Second line, my lord. Iman Tarike Sitar Dia Chokro Bishayar Mohodoyor 19/2011 ইংরেজি তারিখত হুকুম মতে ইমান সূত্রে 1 নম্বৰ মৃত পাট্টাদাৰৰ ৱাৰিছ শ্ৰী মণ্ডল দাস পিতা সুৱেঞ্চ স্থলত, second line towards the end, স্থলত ইমান নম্বৰ দাগৰ ইমান বিঘা মাটিত Topsem India Limited Lohia house number সুৱেঞ্চ represented by Bajrang Lohia.
But Mr. Mazumdar, please come to page 39.
Madam. Yes. Madam.
Please read the last paragraph.
It is therefore prayed that your honor would be pleased to withdraw the said notice and the said company is ready and willing to invest more than rupees 100 crores to complete the mega project, which is actually approved by the high power committee under the chairmanship of the Honorable Chief Minister. And if your honor does to not withdraw the said notice, a fresh notice may be issued in the name of the said company, and the right of personal hearing may be given.
To that extent, there is a
My lord,
concession.
My lord, I just wanted to point out next this one only. In this reply, where has he mentioned that, see, it is not the Topsam India Limited is not the owner. They have only said that it's a purchase by Topsam India Limited, but in the meantime, see, this reply was submitted on 28th of October 2014, my lord.
Correct.
And now, if your lordship comes to page 27,
Yes.
22nd of February 2011 itself, there was a change. Why did you not point out? You were suppressing. It is a reply in 2014, my lord. You are only saying that, see, it was purchased by Topsam India Limited, but in the meantime, there is a change in the writ petition, a specific plea is taken that, see, in the name of the original owner, there is no proceeding. Now, you have never disclosed how the Deputy Commissioner, who is concerned only with the revenue record and not the industrial policy of the government, my lord, will know that there has been a change in the ownership or the character of the organization which purchased. Page 27, my lord.
27 we have seen, but in the reply,
My lord.
isn't there any mention of the change of? I think
No.
there is.
No, my lord.
Mhm.
The reply possibility is not written.
Okay. You may have a point. Because in the penultimate paragraph,
My lord.
the reply is that the said company is ready and willing.
Yes.
As on 14, there is no company.
Yes. Yes. You are deliberately withdraw.
As on 14, there is no company.
My lord. There is no company. It's a partnership.
They simply, the vision is that there is a company which has purchased.
Yes.
I am nobody.
I'm nobody.
So if
But
the
who is the present owner? No disclosure.
and if the company is ready and willing to invest,
Yes.
and you maybe issued in the name of the said company,
Yes.
and the right of personal hearing.
Yes. So
This
you
may be
want-
one of your points.
My lord. So the petitioner wants that the authority should proceed against the company,
Which is
so
not
that-
there.
which is not there, so that ultimately they can take a plea they see against the real owner. There was no proceeding because everything has been written, but it is not written as to why the Topsam India is no longer the owner, and they say that it was purchased in the name of the Topsam.
No, that is correct.
My lord.
Purchase was
In the name of-
indeed
that
in
is
the name of
correct.
the company.
That is correct.
But in the meantime, there was a
Change
change.
in 2011.
11.
Right.
And these proceedings started
In 2014, 13-14, my lord. Yes.
14.
Yes.
And reply nowhere even makes a whisper that there is a change in the entity.
Yes.
Rather, you say that give the company a chance, they'll
Yes.
respond.
Yes. So, my lord, on the on the point as to, on the objection as to whether notice has been given to the actual owner or not, possibly the petitioner will not have any case because they did not disclose their own identity. My lord, apart from that, now you are the person, page 28, if your lordship.
28.
28.
Yes.
It is a continuation of 27.
Yes.
That certificate of
Yes, yes.
transfer from TopSem to TopSem LLP.
Mm-hmm.
Lordship will find right hand side,
Oh,
he is the designated partner
right?
number 1.
Yes.
Now, if your lordship goes to the Act of 2008, lordship will find in section 20. Okay.
2000?
2008. This
Which
is
act?
limited liability
LLP
partnership.
Act, LLP Act. Receipt of code, receipt under which section, Mr. Mazumdar?
Page 26, section 26, ma'am.
26.
Right. Section 26, every partner of a limited liability partnership is, for the purposes of the business of the limited liability
Same as the
partnership.
Partnership Act almost.
Yes, my lord. Agent of the agent of the limited liability partnership, but not for other partners. He is agent of the main partnership firm, my lord.
Act. Okay.
Yes, and in the document whereby the petition number 2 was authorized to file this writ petition, says that he will represent even the partners also. It is annexed here. So he is representing not only.
Where is it annexed?
It is in the my lord, document based on which the writ petition.
27.
It is there. Page 42, my lord.
42.
My lord.
Even otherwise, by the Act, he represents.
Under the Act, he will represent the firm,
Firm.
but and not the partners. But under the authorization to represent this, for the partners also, he is to represent.
Okay.
Page 42, my lord, second paragraph.
Okay, okay. Oh, there's a resolution.
Yes. Resolve that so and so be and is hereby appointed, nominated, and authorized to institute and or defend any proceeding case suit on behalf of the LLP as well as its designated partners and partners. So this shows, my lord, for all practical purposes, it is the petition number 2 who was the director of the TopSem India Limited and the main person who will represent. Now, another question arises, my lord. After you purchased, after you mutated in your name, lordship will kindly see this mutation took place in 2000 May 2011. February 2011, the company got transferred to partnership firm. You should have immediately informed the revenue authority, kindly change the mutation also in the name of the new company. Otherwise, if any proceeding is to be initiated, it will be initiated against the authority which is recorded in the record even after they changed in 2011.
Please come again. Please give the dates.
To 19, I'm sorry, my lord.
No, the year will be, the month will be enough.
Yes, February 2011 is the conversion to partnership. And April 2011, May 2011, this mutation took place, but again in the name of TopSem India Limited, represented by petition number 2, Bajrang Lohia. So where does the Deputy Commissioner get the name of LLP, my lord? They do have no record. Now, if, my lord, if I have been able to satisfy your lordship that as far as notice is concerned, the Deputy Commissioner doesn't have any notice that there was a change in the organization. And ultimately in the reply also, when you write a reply, you should have specifically mentioned in the very first paragraph that you have issued the notice in my name. Presently, there has been a change in the nature of the organization from TopSem India Limited to TopSem LLP. Finally issue notice to them. Because, my lord, the land and your lordship is available, if there is a change, etc., conversion, all assets and liabilities will get transferred to the new.
Yes.
So that company has the liability to respond. That is one aspect of the matter, my lord, about the notice. Now, about the form, this draft statement, etc., your lordship has seen, this section is very clear. No prior notice before. Lordship will kindly see once again, my lord.
Yes.
Yes. Now, my lord, section 4 speaks about the limit in the act. And
Yes.
yes. So, lordship has seen, my lord, section 4 speaks about sealing on existing holdings. Now, section 5 says submission of return by person holding land in excess of the ceiling. Any person who, on the date of commencement of
See,
this,
4, 5, we have expressed our opinion. Perhaps
Yes.
4 or 5 will be not applicable.
my lord,
He was not an existing person
No.
at the time of the commencement of this act.
yes,
He came into
subsequently.
subsequent. The
Yes.
subsequent will be 20 and 21.
Yes. Now, about the draft statement, etc., they say if they fail, we should have given.
No, draft
Now-
statement is by whom?
Yes, my lord. That's
Draft
why I
statement-
wanted to refer to
draft
section 5.
statement
Owner.
is the owner. No, you have to read the draft statement. See, kindly. See, kindly come to 5.
5
Five.
first, my lord. Section,
Please
my lord.
read. Please read.
Section, my lord.
Yes.
Any person who, on the date of commencement of this act,
Yes.
holds as owner
Yes.
or tenant lands which in the aggregate exceed the limit fixed under section 4 above, shall within the prescribed period submit to the collector. Your lordship is absolutely correct, my lord. Submit.
So this 5
Prescribed
is
period.
yes. At the time of the commencement of the act, if somebody is in possession of excess land,
Absolutely.
he is required by law to submit a return.
Mind.
That is not applicable, will not be applicable
it
for
is a-
persons who subsequently
Absolutely.
acquires land.
Yes.
So only thing is 20 and 21.
20 and 21. 20 is very clear, my lord. Notwithstanding anything to the contrary in any law, usage, contract or agreement form from and after the commencement of this act, no person
Yes.
as owner or tenant or mortgagee in possession shall acquire or possess by transfer, exchange, lease, agreement or settlement any land which or without the land already held by him or any member of his family shall in the aggregate exceed the limit.
So limit is given under section 4.
4.
Exceeding this limit after the commencement of the act, whatever it may be the law, anywhere there is a non-obstante clause, you
Yes.
cannot acquire land which is more than the limit.
Yes, and
There is a bar.
Yes, madam.
And if you do so, there will be a penalty.
Yes, madam. And no, madam, subsection 2 of section 20 says if there is any document that is madam sale deed, even the sale deed will be bad. And then section 21, penalty. This is the penalty which we have, my lord, taken. Now, here I have to point out, my lord, one aspect of 2015 Act, my lord. 2015 Act, my lord, is enacted for the purpose of regulating the procedure for reclassification, where there is no land is not being used for agricultural purpose. But here, section 3, my lord, subsection Roman 2 is very important.
Two.
My lord.
Yes.
Lordship is having a copy of 2015 Act.
Yes, yes.
Yes. Section 2, Lordship can say no person shall use or transfer agricultural land for intended non-agricultural purposes without
Yeah, not two,
reclassification.
three.
Well, first I am pointing out 3 itself.
3. Yes.
3 says no person shall use
Yes.
or transfer
Hmm.
agricultural land for intended non-agricultural purposes without reclassification and permission in the manner as mentioned here in below. So, if it was a, my lord, agricultural land, without reclassification, there could not have been any transfer.
Hmm.
The vendor could not have transferred, my lord. This is what I am trying to indicate first. And there is a specific averment in the writ petition, my lord. In paragraph 59, Lordship may kindly take note of.
Just a minute, please.
My lord.
Regular question. Regular question. This has nothing, this act has got nothing to do with the Sealing Act. It is only on the reclassification part.
Absolutely, absolutely.
If it is agricultural land,
Yes.
unless it is reclassified,
There can
you
be-
cannot transfer it for any other purpose other than agriculture.
Yes.
That is the purpose
Yes,
of
my
this
lord.
act.
Absolutely. And my lord, what I was trying to point out, here when there is a bar for transfer for a purpose which is intended to be non-agricultural, then it is barred. Now there is a clear statement in paragraph 59 of the writ petition, my lord, that they have purchased it for setting up an industry for mega project. So with the intention of making a mega project, you want to purchase an agricultural land. Before you purchase, before the sale deed is executed and registered, there has to be a reclassification. Well, I'll go to the issue of reclassification later, but here I'll just point out, say, lest I forget, my lord, reclassification process under the 2015 Act is independent of any action to be taken under this 1956 Act. This has got no connection, as your lordship just now pointed out. There is no connection. And also, here, my lord, the writ petitioner, in my humble submission, has joined 3 issues in one writ petition. One, the proceeding under the 56 Act, which is under challenge. Second, reclassification process. Lordship will find here, there are some documents which say that for him some process was undertaken, but ultimately what happened, there is nothing. And third, some document by the high power committee that for a mega project, they have got a environment clearance, etc., etc. Those 3 things are 3 independent process. Deputy Commissioner's action cannot be doubted or cannot be challenged on the ground that the government is sitting in dispute is because government is not aware.
But Mr. Mazumdar,
My lord.
this Act of 2015
My lord.
stipulates that agricultural land cannot be transferred for a non-agricultural purpose unless there is a reclassification.
My lord.
So this is of date of 2015.
My lord.
He purchased land in 2008.
My lord.
So how do you apply this land,
My lord.
this act?
My lord, the process is not yet complete. Now it is coming to force. Now they are.
No.
My lord.
The bar
My lord.
put by 2015 Act,
My lord.
how will it be retrospective in effect?
My lord, assuming that it is not retrospective, today when you are asking for reclassification, Lordship will kindly see section 3, Roman 2.
Section 3?
Section 3, Roman 2 of this 2015 Act.
Yes, yes.
No agricultural land shall be transferred or intended non-agricultural purpose without the prior permission of the Deputy Commissioner.
Yes.
The Deputy Commissioner shall be competent to accord permission only for reclassification of the said land.
Yes.
This also says that at the time of purchase, if the act was in vogue, then matter would have been different. But today, the land is still continuing to be agricultural land.
No, here we need to, it requires deliberation. This is the next question. But prima facie, is the 2015 Act would be applicable?
Assuming, my lord, assuming for the time being, for the sake
So
of...
far as your first argument is concerned, first means on the merits,
My lord.
that section 20
My lord.
puts a bar
My lord.
for any person to acquire land which is more than the ceiling.
My lord.
So far as existing person who are having land more than the ceiling,
My lord.
for them 4 and 5, 4 is the limit, 5 will come in, give a draft,
My lord.
then they'll take action as per law to remove the excess and give it to whomever.
My lord.
Persons, there is a bar already for a new person after this act to acquire land which is more than the ceiling.
My lord.
Now for that bar, if you contravene, 21 comes in. So that is what we are
My
on
lord,
the,
my
at the same time, 2015 Act has also been placed before us.
Right.
15 says that unless you reclassify agriculture land in
cannot be
non,
sale.
you cannot even transfer. But 15 perhaps may not have an application.
Well, if it has a prospective effect, but
It has,
sale may not be-
all law has prospective effect unless,
My lord, I accept that. If it has
unless it is
prospective
a
effect-
court-made law.
My lord,
These are,
sale may not be bad on this count,
yes,
but under the 56 Act, it is bad.
56, yes, 56 you still have.
Now, my lord, now when in the writ petition there is a prayer that kindly direct the authority to reclassify.
Hmm.
Now, for reclassification, my lord, the entire authority is given to the deputy commissioner under this act, my lord.
No, a present reclassification will not rectify
My lord.
a transaction which has been done in
My lord,
2008.
it is what I'm saying.
That
Just
will
for
not help.
pointing
That
out,
will
my
not
lord,
help. That will not
I
help.
am making a submission that there is a prayer in the writ petition that kindly direct the authority to reclassify. Now, reclassification is a process which is to be undertaken by the deputy commissioner, and ultimately it has to be approved by the government also. Now, for that, in the writ petition, there are some averment that some process was undertaken, but ultimately what happened, there is no disclosure in the writ petition. We do not know, but fact remains that since the prayer has been made, it means that they have not obtained any document of reclassification.
That you are correct from their conduct. They are also aware that this still remains to be an agricultural land.
Yes.
But having said that, since land has been defined under
My-
3F
My lord.
to be agricultural land, and
Yes.
Division Bench in Bordeaux has reiterated, or rather has explained that it will be confined to only agricultural land and the other expression,
Well,
buildings and all.
Well, I've seen the judgment. In that case, on this,
So,
Goswami said
yes.
that in the report submitted, and of course there was some lapses on the part of the
Yes.
at that time.
Yes.
In the report submitted,
There was no returns filed
in the-
by the state.
yes,
So
and in
those
the-
were stated to be held to be uncontroverted.
Yes, and some reporter was there who said that sal trees were there.
Yes.
So there was no agriculture activity
Yes,
there.
yes.
That was an admitted fact. But here we do not find that there is
No,
no,
we are not on the facts. We are on the law laid down.
my lord.
That if it is not agricultural land, it will not fall under the
Yes,
Filling Act.
yes.
So now here there are certain documents,
My lord.
including certificates,
My lord.
which the petitioners are relying
My
upon,
lord.
that these were not in agriculture use for the last more than 10 years.
My lord, those documents, my lord, I am not sure which document my lord is referring to.
There are certificates. We can just point it out to you.
My lord.
Come to 77.
Yes. My lord,
So say the vernacular is at 76.
yes.
ইয়াৰ দ্বাৰা প্ৰতিবেদন দিয়া সেভেনশো ইংৰাজী মজুদাৰ মাটিৰ দাগ আৰু পাট্টা নাম্বাৰ ক্ৰমে আৰু উপৰোক্ত জমিখিনি সম্ভৱতঃ 10 বছৰ ধৰি চন পৰি আছে।
My lord, this certificate in my humble submission issued by president of some Gaon Panchayat will have absolutely no bearing on any process to be undertaken under the 2015 Act. Who is he, my lord? And from him, with all respect, my lord, it's very easy to get a document. This document is of, my lord,
Now, we can make this argument still in the context of the 2019 56 Act. You cannot bring in this 2015 Act.
My lord, 15 Act, I am not bringing, I am not
Now you
required.
said just now.
My lord,
2015
no,
Act.
what I am saying is, my lord, under 2015 Act, they are not entitled. This submission I need not make for the simple reason that even according to the petitioner, under the 2015, they were not granted the reclassification till now. So it's still continue to be agricultural land. And this certificate they are producing here from the president of Gaon Panchayat is, in my humble submission, is of no, my lord, consequence. It is inconsequential. This will not help them. Authority says they themselves will acquire a report. My lord, there is a procedure. If your lordship wants me, I can take your lordship to the procedure.
Which procedure?
That for reclassification, what is the procedure to be undertaken by the deputy commissioner? This
No,
is
reclassification as a matter of a requirement of statute will come post 2015.
yes.
Now, we cannot go to 2015. We are in 2008
Yes.
when the lands were procured.
Absolutely, my lord.
Now we have to examine what was the nature of the land.
Yes.
If it was agricultural land, whether there are enough materials to show that it ceased to be agricultural land from a long time. But whether this certificate will be a conclusive
My lord.
evidence.
My lord, this is it.
But the main question will still remain.
My lord.
The entire proposal
My lord.
was not only routed through the proper channel, a high-powered committee had examined the proposal.
My lord, here.
And
my
while
lord,
examining, the aspect of land is definitely one of the consideration.
No, my lord, that is what I'm saying. The authority is not, my lord, petition is also not saying in the petition that the authority is aware that I am going to set up this industry in a place where there is a proceeding under the 56 Act.
No, the proceeding started when? Proceeding started later.
My lord, proceeding started later, but authority
At
is,
that time, it was not.
my lord,
See, at the time of acquiring the land,
My lord.
we are not for a moment even saying
my lord,
that the Sealing Act will not come into
my lord,
force.
my lord.
He might have contravened 20.
Right.
Their consequences 21 may still follow. But the land was acquired by him. The legality part, we are not making any comment
Right.
at this stage. On this land,
My lord,
a project was being envisaged,
my lord.
project was submitted, it went through various processes, high-powered committee constituted, approved, tax incentive, anti-tax incentives. The central government has given clearance, the environmental department given clearance.
Those things they have produced, my lord.
Now, while giving that,
My lord.
this very important aspect on the process of acquiring the land,
My lord,
will that not come into the
in my humble
by your
submission,
conduct?
my lord, by my submission in this regard will be, the authority did not have any information that this land is in excess of or in violation of section the 52nd.
No. See, the facts, the area of land, we have to assume that that was placed before you. How do you approve a project if the area of land was not given to you?
Well, area alone possibly.
Once the area is given, a law, 56 law, you are the first person to be aware of it. He may be the last person.
Well, so
You're the government.
well, so deputy commissioner is not the government, man. He is
No,
not aware.
not the deputy commissioner, entire you are representing the government.
No, I am representing, but so far as the
Government
action taken by
took
the
a conscious call that you go ahead.
I don't.
We are giving you incentive.
Today, your lordship is examining the validity of an order passed by the deputy commissioner. Deputy commissioner is not aware of what is going on between the petitioner and the government on other spheres, man. So far as the deputy commissioner is concerned, they have come to know there is an inquiry also. Lordship can say there is a huge report at page 59.
59.
59. As far as the deputy commissioner's office is concerned, they are aware of this fact only. Page 59, my lord. This is the report based on which ultimately the order was issued. Facts as per records. Once the so-and-so director, my lord, this is Lordship can see.
What is the date of this?
Date is, my lord. Yes, ma'am. This forwarding letter is at page 58, 19/9/2014. The subject of this letter itself shows an inquiry regarding allegation of possessing ceiling excess land. Says, my lord, facts as per records. Once the so-and-so director, Topsam India Limited, purchased an area of land measuring 147 bigha 2 katha 11 lessa in 2 villages, namely so-and-so, during 2008-2009. Details in Annexure A. The purchased land is agricultural land.
Okay, what is on record to show that the land is agricultural land? I'm not asking either you or Mr. Roy to assert something.
Madam.
What is the material on record to show that the land is agricultural land?
My lord, it is an admitted.
We are
fact-
not, no, not admitted.
My lord,
We are not on reclassification. We are neither here. All lands may not be agricultural lands.
my lord.
Is there any material to show that the land is agricultural or any inquiry done to come to the to ascertain the status of the land?
My lord, the petitioner himself is, the petitioners, two petitioners, they themselves are saying that it is an agricultural land and there is a process for reclassification.
No, that is okay.
My lord,
That is why I said
My
you
lord.
it is not, you are not in the assertion.
my lord.
You may say that it is agricultural. Is there any material to show that these are agricultural lands?
My lord, it is recorded as agricultural land.
Where?
My lord, yes.
Kindly show us.
It is there, my lord.
What does this sale deed describe?
Yes, my lord. Come.
The land?
Page 51 is the CD, my lord.
In the land records, what do you mean by Bautoli? The Srini at page 46?
Page 46.
What is this? What is the meaning of Bautoli? Prottek Dagor Matir, number, Kali, then Srini. Class.
Yes. Stanio,
No, you come to page 46.
page 46, my lord.
Yes,
Which-
6, column number 6.
16.
Srini.
Bahutoli, possibly it is the name of Seni
Srini is the class.
class. My lord.
What is Bautoli?
I have no idea what Bahutoli. Huh? Bao. According to my learned friend, Bahutoli means where bao cultivation is done.
Oh, cultivable land.
Ah.
Mr. Roy, what is Bautoli?
Actually, Lordship, actually it is a Baudan.
Baudan.
Yes.
The class still was cultivation, but you say that it was not cultivated for the last more than 10 years.
In city of Guwahati, Lordship, people still already have submitted.
And that is why.
Land records are not up to date.
My lord, that is why under the Act, although it is classified as an agricultural land, but if no agricultural activities has been going on for the last 10 years, then there may be an application for reclassification. So for that, they will have to undertake that exercise.
That requirement was not there in 2008.
2008, my lord, it was already an agricultural land.
No,
So
that was
they have never
requirement was
freed.
not there to declassify.
My lord, moment they found that.
So how do you come to a finding? You have to make a factual determination in 2008. Or if you
No,
proceed,
but it is there.
when you had proceeded in
application-
2014.
My lord, yes. No, application, they have also started the making application, etc. subsequently. Subsequently. What you will find in the petition itself. From 2013, they have started the process for reclassification. They have mentioned para 36. A meeting of high officials of government of Assam was held in so were present for discussing the procedure of declaration of the agricultural land.
See, for you can very easily argue that the process of setting up the project and the impugned action are not connected. These are on a different,
Yes.
it's very easy. The ceiling surplus has got nothing to do with the setting up
That
a
is what
project.
I want to say.
And you set up a project within the limited thing.
Yes, yes.
That is not your objection. Your objection is that you have violated the law so far as 1956 Act is concerned. But having said that, while going through the process
My lord.
and approving their project, this aspect, which is a very relevant aspect, was there, but still you went ahead. You could have very well said that there is a violation of law so far as the land is concerned. There is no question of approval. Central government also. And once it is done, we have to presume that we have done due diligence. And not only his company, there are 3 others companies, including one distillery. He is also making out a case of 14 violation. That we may not be too much impressed, because if there is a violation of law, question of 14 will not come.
Yeah.
There is a status quo pending, a status quo order passed by the division
Yes,
bench.
yes. Passed by the division bench.
Yes, single bench refused to give interim.
And then matter.
Division bench, and later on after 4 years, remanded back.
Yes, madam.
That we have noted.
2018 marriage register.
Yes. To 25/8/2015, notice was issued, no interim order. Then division bench WA 288 of 2015, 39/15, status quo.
Yes.
And 2018, writ appeal was disposed of with a direction to the single bench to decide, status quo would be maintained.
To remain, yes. Status quo order was passed on 9/5/18, so that has remained.
Status quo was not passed on 9/5/18. Status quo was passed on 30/9/15, the day when the writ appeal was moved. Refusal was on 25/8/15.
In view of the direction issued on 30th of September 2015 to maintain status quo.
30th of September.
Yes, 30th of September.
And that was reiterated by 9/5 while disposing of the writ appeal.
Yes. And in the writ appeal, there was a status quo managed.
That is it, writ appeal when it was moved, status quo started on 39/15.
Yes. In writ appeal 288 of
288.
15.
Yes.
Initially, there was status quo on 30th of
39.
September, so that was maintained. This kind of petition matter ought to be disposed of at the earliest.
Yes, yes.
Because either
That is
way
what
it goes,
This is what we are doing.
either way it goes, because otherwise petitioner has a stake, government also wants a disposal either way. If they get back the land of 90 bigas, then it's. That's my submission, and Lordship will decide.
Lordship, I will please to take up.
Short reply.
Short, Lordship. My learned friend has submitted that how the DC or ADC would have the knowledge regarding the change of the
Ownership.
from
Ownership.
limited company to LLP and all these things, and DC was not aware what is going on with the higher
Well, I have
officials or
completed my
Guwahati
part in
and
that
the
of it.
revenue authorities, Lordship. But
Will,
in
Mr. Mother, will reserve,
all
might
the
not be possible.
in all the official memorandums, Lordship, which I have already placed before your Lordship, the copy has been forwarded to the DC. So that submission of my learned friend that what is going on.
No, on memorandum is not connected with your LLP status.
No.
He is making a submission that your change from a company to an LLP was not within the knowledge of the deputy commissioner.
Lordship, when I filed my objection, Bajrang Lohia file, it is
Yes.
clearly mentioned that.
No, you have not mentioned. You have not mentioned.
Okay, Lordship.
There is no mention
Yeah,
of
okay.
LLP.
But when the writ petition was filed in
Writ petition was
2000
filed before this court.
Yes,
Now they are aware.
now they are, since 2014, they are
Yes.
aware because they had
No,
adhered.
Now, 2004, the lease started after filing of this writ petition 15, the matter is before the court.
Suppose 15, Lordship. So from 15, they had the knowledge and information that the now actual owner is the LLP, not the limited company, Lordship. And the second submission of my learned friend that Bajrang Lohia was one of the partners or directors in the company. That is absolutely not a fair submission, Lordship. But in case of a company, Lordship, For every action, the board resolution has to be taken, Lordship. That is mandatory. And the leading judgment of the apex court
No,
is
that is okay, that we know.
Bank of Travancore.
But here in this LLP thing, apart from the Act of 2008, LLP Act, you have also given a resolution that apart from the petition number 2 being an agent of the LLP would also represent all the partners. That resolution is there.
And apart from that, Lordship, the LLP Act,
2008.
2008, Lordship, one section my learned friend has placed, but my learned friend has not placed, section 20, just 28, sorry. Your Lordship, will please to peruse the section 28 of the LLP Act.
28.
Yes. Action of liability of a partner. A partner is not personally liable, directly or indirectly, for an obligation referred to in subsection 3 of section 27, solely by reason of being a partner of the limited liability partnership. Lordship. So, Lordship, a partner.
No, you have to read 27.
27, Lordship.
Yes.
27 is 27(3) subsection. An obligation of the limited liability partnership, whether arising in contract or otherwise, shall be solely the obligations of the limited liability partnership.
So this is in the context of an action taken against the partnership. Now
Yeah.
you are taking an action on behalf of the partnership.
No, Lordship, for representing either it is a limited company, private limited company, or LLP, Lordship, board resolution is a must, and that is the leading judgment is of 2011, Lordship, 11 SCC, Lordship. In that case, what happened? MD of a company authorized his one of the directors that you will represent the company. Ultimately, matter went to Supreme Court. Supreme Court held, but there was no board resolution. Supreme Court held, Lordship, in the para, Lordship, 14. Your Lordship, will please to peruse. In our view, the judgment under challenge is liable to be set aside because the respondent had not produced any evidence to prove that Sri Ashok K. Shukla was approved as a director of the company, and a resolution was passed by the board of directors of the company to file suit against the appellant and authorize Sri Ashok K. Shukla to do so. The letter of authority issued by Sri Raj K. Shukla, who described himself as the chief executive officer of the company, was nothing but a scrap of paper, because no resolution was passed by the board of directors delegating its power to Sri Raj K. Shukla to authorize another person to file suit on behalf of the company. So law is very clear, Lordship. If today a person may represent a company if he is authorized by the board of directors resolution. If he is not authorized, next time he cannot act. My learned friend has submitted that in all the sale deeds of this and that, he has represented the company. At that time, he was authorized. But in the present case, when he became the partner of the LLP, he was not authorized.
Admit here that Bajrang Lohiya was representing all the partners. So ये resolution को बता के, लेकिन ये resolution just to take legal steps था ना 2015 जब notice was released to file the case. ये resolution से हम लोग just to bring the cases represented. नहीं जब ये तो हम ले जब the Bajrang Lohiya was appointed as a authorized partner.
Okay.
My learned friend further submitted that the Annexure 5, page 42, Lordship, which is a resolution passed by the Board of the LLP, Lordship. Here, the Bajrang Lohia was only authorized to initiate the filing of the writ petition. That your Lordship will find at page 42, para 2, Lordship, second para, that Shri Bajrang Lohia is hereby appointed, nominated and authorized to institute for and on behalf of proceeding case suit on behalf of the LLP as well as designated partner before competent authority or court. So he was just given the authority to file the matter, okay, writ, Lordship, nothing else. Then, your Lordship, I would like to place before your Lordship how the statutory provisions were violated. Your Lordship, may be pleased to take up the rules of the Act 1950, Rules 1957.
Yes. Which one?
Rules, which rule? Rules 3. 3. First of all, Lordship, before reading 3 rules, according to me, Lordship, the land was not agricultural. That's why the filing of the return for excess land does not arise in my case, Lordship. Then I am placing rule 3. The period which the return shall be furnished by a person under section 5 of the Act shall be 3 months from the date of this.
This 3, we have, I think we have discussed. 3 is in connection with section 5.
Yes, no,
At the time of coming into operation of this Act 1956.
No,
It
your
will not
Lordship,
be connected with your
section 4, your Lordship.
4. Rule 4.
Rule 4.
Rule 4, please.
If the return under the preceding rule is not submitted within the prescribed period in that rule, then the collector shall obtain the information prescribed in sub-rule 2, 3, 4, 5 of the preceding rule through the agency of the settlement officer and his staff, where a settlement operation is progress, and though the circle officer, sub-deputy collector, has his staff where on such settlement operation is progress or through any such government agency, and the state government may by order direct the settlement officer of the circle officer, deputy collector, as the case may, shall also furnish the collector with the following information: the plot number, location, area not exceeding limit fixed under section 4 of the land which he recommends or the retention with the person. B, the plot number, location, area of the excess land which is recommended for the acquisition by the state government, and the description of the building, structure or crop that may exist in any part of the excess land mentioned at above, and the plot number and location of such land. Then Lordship, verification, rule 5. Verification under section 7(1) of the information given. Where a return is submitted duly under section 3, the information.
Sir, right, this
is not relevant.
These rules may not be,
Order of
3, 4 and 5 will not be applicable.
Yes, is Lordship, then irrelevant is this, Lordship. 5B, rule 5B.
Yes.
Where any person transfers or partitions any land in violation of the section 4(5) or section 4(6), then the land remaining with him is less than the excess determined under provisions of the Act. The deficiency shall be acquired from the possession of the transferee of these successors in interest in the following manner. If there is one transferee land to the extent of the deficiency, if there are more than one transferee land or the same proportional as the land transferred to each of these transferees as to aggregate in the total of the deficiency, provided that the transferee shall be given the option to indicate the plot of or plots to be acquired under the provisions of the rule. Then Lordship, this is very important, Rule 6. Manner of service of draft statement subsection 2 of section 7. The draft statement prepared by the collector under subsection 1 of section 7 shall, so far as is practical, be in the form A or form A1, as the case may be. The collector shall serve the draft statement on the person holding the excess land by tendering and delivering a copy thereof him or to his duly authorized person. Nothing was followed, not at all. If sub-rule 3, if such person has agent be found absent, then the draft statement shall be delivered to any adult member of the house in which he ordinarily resides, provided that in case covered by the sub-rule 2, 3 above, the serving officer shall require the signatures of the.
Mr. Roy, these rules will not have any application. It is only Rule 21 will have application. Rule 20 is in connection with Section 20. Please come to Rule 20.
No, Lordship, the Rule 6 are clearly
No,
provide.
this is in connection with 4 and 5.
Yes.
For those persons who were in occupation of land at the time of commencement of the Act. Come to Rule 20, because you purchased the land subsequently. So what you are required to give is a declaration under Section 20 subclause 2. This was not pointed out by Mr. Mazumdar. First come to 22 of the section. Section 20, subsection 2.
Section or rule, Lordship?
Section.
Section is regarding contravention.
No, not only contravention. 22. What are you required to do? Please read 22.
Yes, sir.
Please read. From, yes, please read. From
22.
20, subsection 2.
20 ceiling on future acquisition.
No. 20.
2, okay. Lord.
Yes.
From and after the commencement of this act, no document evidencing any transaction for acquisition or possession of any land by way of transfer, exchange, lease agreement or settlement shall be registered unless a
declaration is in writing
and duly verified is made filed by the transferee before the competent authority. So it was the transferee duty.
Kindly come to section Rule 20 now.
Rule 20.
Rule 20. Rule 20 gives you the contents of the declaration. There is a procedure prescribed.
Contents of declaration under section 20 and the action to be taken. The
this is lacking in
made under subsection 2.
This is lacking in your case.
No, lacking, Lordship, but according to me, it is not agricultural land. So these rules or sections, whatever your Lordship has pointed,
that is what we are trying to
not apply. Will not
that
apply.
That is what the question was. Show us any materials, not an assertion that this, what is the status of the land?
Pardon, Lordship.
Show us any material on record regarding the status of the land.
Status of the land. Status of land is to be determined by the revenue authority, Lordship. But according to me, Lordship, I have obtained the certificate from the Gaon Panchayat, which is a revenue authority under the Panchayat Act, Lordship. Gaon Pura has given the certificate, Lordship, and that has been not denied by in the affidavit in opposition, Lordship. There is no whisper. Simply they have written no comments. So, Lordship, they are Gaon Pura and Panchayat, they are also the revenue authorities, Lordship. And if it was doubtful or any suspicious circumstances, why the government did not take action against the Gaon Panchayat authority, Lordship? It is a statutory body function under the Panchayat Act, Lordship.
Okay. We'll consider. Sorry, SP Roy, then counsel for the petitioner, also heard Sri D. Mazumdar, learned additional AG, assisted by, yes, who's government counsel, anyone who will be assisting Mr. Madam Borman? Okay. Hearing is concluded, judgment is reserved. Okay. We will consider.
Nice.
Four na ki to. Not hoise na?
May it please your lordship. My lord, may your lordship may peruse the page 81.
Where is the government council? Just wait for a while.
Because my only submission, my lord, the
Let him come, we'll have the submission in his presence. Yes, a bit, or admission to set. Yes, Mr. Nath. Just a minute, madam.
Yes.
Let's complete this.
Yes.
my lord, before my train starts, what I want to place is this. At page 81, your lordship will find
81.
81. 81. This is the impugned notice.
Yes.
Well, the date is 11/8/25. Third line, it is said, shops, houses over the land recorded as government dag number. Class nil remark bill are situated near the bill. Nothing more is there. Though it is a government coded as government dag number, its resemblance is a government khas land. And my lord, another thing, will vacate the encroached land within 15 days from the date of receiving the notice. 11 from if I take it, I have received on 11, today is 26. How could they vacate it on today, man? That itself, it is against their order.
11/8/15/26.
Today is 15th. They could not have vacated my premises, man. They could not have done that today. At least we get that. If it is of Supreme Court also, Supreme Court has said, give a hearing in the Pan-Asian case.
Yes, Mr. Nath.
But I have instructed them to stop. Something was going on. I have directed them to stop.
No, it's not a question of you directing them.
That's true. That's true.
It is for them. These matters are not required to be advised at the last moment.
Correct. I have.
Now, what is your submission on this?
I have received
First,
the short instruction from the ADC I have received. They said that I'm just placing it. It will be just.
no, Mr. Roy Chaudhary is
Well,
on the point of law that individual notice, number one. Number two, even if you overcome that aspect, in your notice, you give them 15 days time from 11. Today is the penultimate day. Till today, they had the time. So, at least the period which you have stipulated, you have to wait till that period is over. That is without even going to the merits of the dispute.
That's
whatever points, assuming that we are against the petitioner, but still then 15 days. So what is your instruction?
My instruction given by them is, they said that the land is as per Sita recorded as Panitol. This is Panitol, this is water body. And they have said that in the Honorable Apex Court decision, I have given the copy, I have flag marked para 6, the Honorable Apex Court has said that the order of the Honorable Apex Court is not applicable if there is an unauthorized structure in any public place such as road, street, footpath, between railway line, a river body or water bodies. So they said this is water body, the land is water body Panitol as per Sita. Therefore,
what is the order of 17th September?
I have given the order.
17th September is here.
I have, yes, Lord.
No, this caveat which was given at page 6. Wide order dated 17th September, we directed that there shall be no demolition anywhere across the country without seeking leave. However, we clarified that our order would not be applicable, so and so, so and so. Huh? Where is the 17th September order, 2024?
The order runs into, it's a long order, Malad. I have taken
No, not this order. We want the earlier order,
17th,
which has been quoted.
Malad.
Okay, You said this is
Lordship,
Panitol.
Panitol.
You do one thing. You file an affidavit.
Mal.
We'll give you a short time,
Lordship,
1 week's time,
Lordship,
but
we'll
maintain
file.
status quo.
We'll file.
We are not
Lordship.
passing any order, you direct your officers.
Yes, yes, my lord.
Your lordship
As
will
a- as a-
observe that, my lord.
Yes,
because
yes.
No, we'll record his statement,
Yes, yes.
but we are not inclined to give any blanket interim order. This is a public interest is involved. But you, how soon can you file the affidavit?
But
Can I have this matter on Friday?
by Lordship, to this.
Or is there anything on record to show that this class of land is Panitol land?
My lord, I have received the instructions today. The
No.
ADC's letter is there.
No,
I have
that's
asked for the CITA copy.
not the instructions or the documents which you have received.
Lordship.
Before this court, in this petition, is there any
No.
material?
No,
Then
no,
you
no.
have to file an affidavit, I think. If that was there on that basis also, we could
But
have.
the
Hart
petitioners have,
Street,
petitioners have given nothing, my lord.
Hart Street PK
And I just
Chaudhary,
have to-
learned counsel for the petitioners. Also Hart Street G. Nath, learned senior government advocate Assam Para. Sri Roy Chaudhary, the learned counsel, has submitted that despite the matter being fixed today and as per the impugned notice 11/8/2025, 15 days time was granted for eviction, the demolition activities had started from today itself. Para. Sri Nath, the learned state council, has however submitted that the land involved is of the Panitol class, Panitol, and the Honorable Supreme Court in the judgment dated so and so report in WPC 295 of 2022 had itself clarified that the restriction would not be applicable to certain categories of land, including a land of this nature. Full stop. He has also submitted that demolition activity, if any, and that he has advised that demolition activity is if any, should be temporarily stopped. Full stop. Para. Let an affidavit be filed by the state in this regard, for which how much time?
By Friday, I'll file.
In this regard, full stop. Sri Nath, the learned state council, has assured that the affidavit would be filed within the shortest possible time. Full stop. Para. Considering the dispute involved and the urgency expressed, list this case on Friday, before which the affidavit is required to be filed. Till the next date fixed, status quo as on today be maintained. Full stop. The aforesaid order of status quo would, however, be reconsidered after filing of the affidavit. Six. Yes, what is this?
Yes. Actually, in this writ petition is Kalpana Saha. She expired on 24th 10/2024. Subsequently, his legal error has been have been substituted in this case.
Yes.
On 2/4/2025. Lordship, in this case, Lordship, I have filed a writ petition for inaction of the respondent authority, that is JMC and GMDA.
Sir, not for whom?
For a private respondent.
GMC, GMDA? GMC, GMDA, Mr. S. Bora, Mr. Nayak. Please call Mr. Bora or Mr. Nayak. What is your grievance, madam?
Lordship, in this We are the owner of a land measuring 11 lessons of under KP Patta number.
That is okay. What is your grievance? Now you have.
This is that Lordship, the respondent number 529, they are the neighbor of my, of the petitioners. And they have constructed a building over their land without keeping the setback that is provided under their permission granted by the GMC and GMD. And without keeping the
Did you complain before the GMC, GMD?
Yes, Lordship.
What did they do?
They did not.
No action.
No action has been taken till today.
Yes.
That is why.
Madam Bothakur Borua, where is the senior? Who is coming? Nayak or Bora?
Mr. Nayak was supposed to appear, however, he's on legs, Your Lordship.
Whole matter, he should come. 17 matters.
Lordship, an inspection was undertaken by the GMC department. Since there was no permanent structure between the two plots of land, Lordship, the northern side could not be measured. That is the issue, Lordship.
No permanent structure, no permanent boundary.
Lordship.
There is
Mr. Nath, you are for the private respondent.
My
What
case
is what?
that, my lord, admittedly, there is civil dispute with the party.
Yes.
And the petitioner side have already approached a proper civil forum, that is the Civil Just Senior Division number 1, and they have filed one title suit against us. So, this.
Title suit is on what subject?
In the similar boundary dispute matter.
No, Lordship.
I have enclosed the, plea, filing title suit, my lord, at page 61, the para. Page 61, my lord.
Who is the plaintiff?
The petitioner here in mind. The similar steps of petitioner. They are the plaintiff there.
Kalpana Saha. Oh, 2016. Oh.
Yes, ma'am.
What has happened here in this case?
The suit is presently pending adjudication and the parties have laid evidence, my lord. Even
Madam, what is this title suit?
Title suit regarding they have attempted to occupy one portion of our land. That is why, Lordship, we have filed a title suit for right title interest and confirmation of possession of over the land under DAG number 110, and their DAG 1101, and their DAG number is 1102, Lordship. That is two different plot of land, Lordship. And in that case,
No, madam, come to your the page internal page 8 of the
yes,
of the plaint. Without keeping 5 feet land from the boundary of the plaintiff, that is one of the prayer.
that is not the prayer there.
No, that is one of the prayer in this. We are reading the plaint, not your
It is
repetition.
their land, Lordship. It is not my land. Because
No, come
112,
come to prayer number 3. Prayer number 3 of the plaint.
plain,
No, not 3. Second prayer of the plaint.
Lordship.
Yes. Internal page 7. Permanent injunction restraining the defendants and man agent and employees from entering into suit land of the plan constructing any building without keeping 5 feet land from the boundary wall.
That is their boundary. Our boundary is different, Lordship. That is my southern side. Their land exists. And in that case, they
It is in the southern, plaint is also in the southern side.
they are no, southern side.
Yes, plaint is also in the southern side.
In southern side,
Yes.
then we have, because they attempted to occupy inside our land in southern boundary. That is why we have filed the title suit, Lordship. And this case is with construction over the land, their land 1102, that is DAG number, that is a distinct and different from the title suit, Lordship. And in that case, injunction was granted by the learned court below. And subsequently, they started construction occupying. Now they have removed that. There is dispute is going on regarding that my 1101 and 1102. They have constructed without keeping 5 feet, 8 feet as required under the planning permit granted to the opposite party, Lordship. That is page 3. Page 21, paragraph, annexure 3, Lordship.
Not very clear.
Lordship, kindly turn to page 21, column 7, that is northern side.
GMD
Their
has filed,
northern side is
GMD has filed affidavit.
Yes.
Filer.
They
What do you
have
say?
filed, but they have mentioned about that they have inspected. And I have filed a reply, then they never inspected the land, Lordship, as directed by this honorable
Lordship,
court.
we have already annexed our status report in our affidavit, Lordship, at page 80. It should be
81,
page
Lordship, that is
85.
80?
81.
Or status report is against. Permission. There's no final boundary line. Paragraph 3.
This was issued.
They had visited on 11/9/20.
Yes, they have stated, Lordship, no notice has been given to us, anything they, and kindly turn to page 79 of this affidavit, Lordship. There is
Yes,
no,
that is what we
there is nothing in the, when they have signed the affidavit before this honorable court. Page 80.
Yes, it was filed on 13 March 2019.
They have served a copy on page 80.
Identified on 12th March 2019.
But in our, they have served the copy, Lordship, without anything.
In your copy, there may not be a signature.
Signature is not required,
Yeah.
but I signed this affidavit like,
That is there.
that is required.
That is there. It is
And
there.
page 81, I have filed an affidavit in reply, that is page 82, Lordship.
Yes.
84, then relevant portion in 84, para 5, Lordship.
What is the reply to paragraph 3?
I have stated that as regard the statements 3 to 4 of the affidavit in opposition were responded with 3 and 4. The answering deponent vehemently denies the statement made therein and state that no official of the Guwahati Municipal Corporation ever inspected the site in question on 11/9/17 and prepared a status report as stated herein. The deponent assert that all till date, no inspection has been made by the respondent authority as directed by the Honorable Court by the order dated 22/8/17, and the respondent number 529 have almost completed construction of the building, violating the conditions of the planning permit as well as the NOC granted by the respondent number 1 and 4. The deponent state that the status report dated as Annexure 10 in the affidavit in opposition was prepared without inspection of the with the inspection of site in question. The deponent further state that she constructed 3-story building with valid permission in the year 2003, keeping 5 feet setback to up to her southern
But
boundary.
these will be all factual disputes.
Yes, for factual dispute.
They have said that they have gone. You said that they have not gone. Then
But,
how do you determine?
Lordship, kindly turn to page. That is the factual fact.
If there are factual disputes,
In the suit, that is suit regarding 1101, regarding DUG number, that is my suit.
no, we
And
are not on the suit part. We are on the aspect
but
that
they have stated in that we have not kept any 5 feet land inside our northern side boundary.
no, madam, we are on the aspect of inspection.
But
GMC has
their
done.
statement,
Yes.
their statement, Lordship, in any place, it is a forum of honorable court also. They have stated, I have not kept any 5 feet land.
Madam, we are not
inside
on
our
that. We are not on that. We are on the inspection part.
inspection part.
On affidavit, they have stated that they have
visited.
visited. You have said that they have not visited. Then this fact,
If they have visited, let them show any documents regarding service of Shomon 2D or any papers regarding they will inspect the boundary without in our absence.
that will be a factual dispute. Factual dispute can you determine? On what they have
Actually,
said,
they have stated.
on
Lordship,
what
it is
they have
up to-
said that they have gone,
it
two
is up-
officers have signed.
It is up to
Let us
Lordship
go.
to see.
No, you may be correct, they may be correct. We cannot determine. We do not have the expertise to determine. Read code. There is no question of adducing any evidence. There is no scope.
They have already constructed 4-story building without keeping any boundary.
Now that northern side, they have also gone to the extent of saying that in the northern side, because of absence of any boundary wall, it could not be ascertained.
Then let them construct boundary wall.
Who will construct?
Who will construct?
You
They will
construct.
not come because they demolished that boundary. That earlier there was a bamboo fencing.
Is there any restriction of constructing boundary wall?
Let him, my
Is there
learning,
any restriction in law of constructing a boundary wall?
because they are disputing Lordship.
No,
That
they
is
are disputing, you know what to do. If there is any law in having a boundary wall construction, you show us the law. You construct the boundary wall on the northern side,
southern side of my
southern side.
southern side.
Then we can keep this pending and we can ask the GMC or GMD to make another inspection because it is only that part they could not ascertain. Rest part they have said it is okay.
They have stated about, but in their northern, I'm not going to their northern side or any other southern side. In that.
Where is your
southern-
trace map, madam? Where is your trace map? Is there any map you have given?
No, Lordship.
We
I
do not
don't-
even know where are you, where is Mr. Nath? Mr. Nath, have you given any sketch map?
Enclose I have enclosed the Jamabandi of their land.
No, no, from the Jamabandi is not easy to ascertain. If you give a sketch map of kind of a rough sketch map, we can understand who is in the north, who is in the south, which part is in dispute. If they want to construct the boundary wall, let them construct. There cannot be any obstruction in constructing boundary wall.
When in the title suit, my lord, one Amin commission was appointed by the landed court below.
Okay.
The Amin commission has visited the spot and they have submitted one report indicating that, in fact, when the trial court had adjudicated upon the issues involved in the said suit, has appointed a commission for submission of a report after conducting a spot verification. The said report dated 22/5/2017 discloses that a defendant, that is the respondent number 5 to 9 herein, has kept a margin of 2.4 meters on the northern side of their boundary, which is admitted to the southern side of the petition.
Lordship, that was rejected by the court. That is rejected by the court. It is in a way.
Trial court.
Commission report, that is also on the record, Lordship.
One report has been called for and it has been categorically stated that we have left the necessary.
No, that report has been accepted or rejected?
No, Lordship.
Hmm?
They have mentioned in their evidence. It is not accepted.
They have filed applications for rejecting the report, but I think I have written their reply, my lord. I have gone to their reply. They have not enclosed anything regarding that the report has been rejected.
The suit is at what stage?
At evidence, cross-examination.
Of whom? Whose evidence?
CW2.
Plaintiff, you are yet to give evidence.
They have,
In the injunction, we have let it go.
there is, yes, in the injunction.
There is an injunction.
Yes,
We
Lordship.
have not opposed the injunction order.
Okay. What is the kind of injunction?
This temporary injunction was granted on 25/11/2000.
No, what kind of?
On their part of land, maintain the status. We have not enclosed their land, so we have not opposed to their injunction order. We have not even filed any written objection.
And violation case, they have adduced evidence and cross-examined by. And in that case also, they have stated that
Madam, is there any difficulty on your part to have the boundary wall constructed? Construct the
if Lordship, they don't dispute, then I
How can,
construct.
if you are constructing?
Yes, on their land, they are always welcome to construct your down.
Oh. Third, Miss M. Dev, Learned Counsel for the petitioner. Also heard Miss A. Botakur appearing on instruction of 3P and Nayak for the GMCA.
GMC and GMD.
GMC and GMD. Sri D. Nath, Learned Counsel, has appeared for the private respondent numbers 5 to
9.
9. Paras. Ms. Bothakur, the Learned Counsel, has submitted that pursuant to the order of this court, an inspection was conducted on 11/9/2017 and findings were given by the zonal engineer as well as by the associate planner. Page 81 side of. He has also drawn the attention of this court to the averments, to the connected averments made in paragraph 3 of the affidavit in opposition filed by the respondent numbers 3 and 4 on 13/3/2019. Para 3. Nath, the Learned Counsel for the private respondents, have submitted that a title suit has been instituted by the petitioner, and the same is at the stage of evidence. He has also submitted a title suit to number, title suit number TS 498 of 2016 in the court of the Civil Judge number 1, Kamrup M, Guwahati. Civil Judge number 1, Senior Division. Civil Judge, not Senior Division. It's Munsif and Civil Judge. Again, Junior Senior. Munsif has gone now.
Yes.
Senior Division. He has also submitted that an injunction order has also been passed for maintaining status quo, to which his clients are not opposed to. Ms. Deb, the Learned Counsel, has disputed the aspect of the inspection made on 11/9/2017 by contending that no notice of such inspection was ever served. Full stop. Be that as it may. No. The aforesaid aspect of the inspection would ultimately turn out to be a factual dispute in which this court may not be in a position to make an effective adjudication. Be that as it may, against serial number 8 of the status report submitted after the said inspection, it is stated that the aspect of setback on the north side could not be ascertained as there was no final boundary line. Full stop. In view of the above, comma. Ms. Deb, the Learned Counsel, has not disputed the aspect that there is no boundary wall on the said part. Full stop. She has, however, added that to facilitate the GMC to make an effective verification, let the boundary wall be constructed by the petitioner on the part where there is no such boundary wall. Full stop. It is also provided that after completion of such construction, comma, the same may be notified. How much time will you require?
For construction.
Yes.
I have to inquire about that portion.
Then you can we can give a date to the within such time.
It will take time.
Will you list it after 2 weeks or 3 weeks?
Yes, Lucy.
3 weeks. Okay. Last weekend, list this matter after 3 weeks. for passing further order, passing further orders on the aspect of making an effective inspection by the GMC.
In the southeast corner of that plot of land, there is a old, actually house is existing,
Whose house?
ours.
It is, if it is in your land,
That is the main landmark of that area, Lordship.
no, here
Southeast.
we are going by the report.
Things, my lord.
Disputing,
Sometime actually house was not in dispute before this honorable court.
no, it is in boundary. That is why I'm stating, what is it not disputing?
No, we are going by the inspection report, which has said that in one part there is no boundary wall. Have the boundary wall constructed, we'll see whether there is setback or not. Okay. Ms. Madam. List of-
Whether I have
list of
to
the three.
demolish that my old house.
If it is crossing over the boundary, you might have to.
I have not crossed. It is in, since 40 years back that house is has been constructed.
Okay, next.
Highly obliged.
Yes, what are this?
Lordship, in this case, actually, adjournment, Lordship, another, kindly go to order dated 25/10/2024, Lordship. An impleachment petition was pending, Lordship, it has not been listed along with
Implement application.
petition.
What is this IA for?
IA for impleachment, Lordship.
No, 2671?
No, it was their stay vacation.
Justification petition.
You want the implement to be listed along with this?
Yes, Lordship.
You have the number
Yes, Lordship, it is a 7370 IA.
of 24.
Yes, Lordship, it was ordered in 25/10/2024 also. 25/10/2020.
Sri P. Sharma, learned counsel for the petitioner has submitted that IA 7370 of 2024 is connected, which has been filed for implement. Full stop. They said IA, however, is not listed today. Para? List these cases along with the aforesaid IA. When? Friday?
Not Friday, next week, Lordship.
After a week.
Next week, that may be fixed also.
On Monday next.
Monday, Lord. Mass obliged.
Date, huh?
Lordship, can it be third, Lordship? Monday, I have matter, Lordship. Please.
On third is okay for you? Third. Interim.
I know.
In item 9, I have filed my Wakalatnama, but this has not come on the record.
Oh, that FIR, Bombay.
Yes, Lord.
Yes.
But you may start with item 10 first.
Your Lordship, I'm appearing in item number 9 on behalf of Dr. Ashok Saraf, who is appearing on behalf of respondent number 1, 2, and 3. I'd like to seek some accommodation in the matter, Your Lordship, for today.
You're for whom?
Respondent number 1, 2, and 3, State of Mumbai, Maharashtra, sorry.
Maharashtra. And madam?
Number 4, the informant.
In item
Okay.
number 9.
There are two matters.
Yes, yes. One is by the company and one is by one of the directors.
Okay. Against the criminal cases.
Yes, Lord. Same criminal case.
In both the matters, Maharashtra is a party.
Yes, Lord.
You appear in both these matters.
No, in one.
In
matter,
item number
there,
9, Your Lordship.
Item number 10.
Huh? Oh, there are two cases.
So in the company matter.
Yes, item number 9.
Okay, you tell us then, you give us a date. Let your power also come. That is okay. That's a formality. If you have said you have filed, it's okay. Yes, when, Mr. Doctor?
Any date in the month of September, Your Lordship?
We'll take it up for final disposal.
Yes,
Yes, Your Lord.
Short date may be given.
there is a stay operating.
Part 3, Ascent Tamuli, learned counsel for the petitioners in these cases also heard Ms. G. Goswami, learned counsel for the respondent number 4.
The inform.
Full stop. 3, and Ms. M. Borman, learned counsel has appeared for the for the state of Maharashtra in WPC 35 of 2023. Full stop. However, an accommodation has been sought for on behalf of Dr. E. Saraf, senior counsel appearing for the state of Maharashtra in WPC
5707.
5707 of 2021. As agreed to by the learned counsel for the parties. Matters are adjourned to be listed when?
11th.
Thursday.
11th of August, okay?
September.
11th of September. Okay. 11th, there may be as a problem. Have it on 16th,
Yes, Lordship.
okay?
Lordship.
16th. Yes.
Lordship, the matter relates to executing the order passed by RERA. Lordship, an order was passed in 2023 in favor of the petitioner, whereby recovery proceeding under the Bengal Recovery Act had to be taken up by the Deputy Commissioner. Lordship, 3 years have been lapsed. They have not taken action as per the Act. They are conducting settlement meetings between both the parties. They have issued warrant of arrest. They are not actively following the warrant of arrest as well.
I have received local comment.
Lordship, it is also pertinent to note that a order was passed by Deputy Commissioner to Circle Officer on 2207.
So we are waiting for some report, Lordship.
What is your prayer in this writ petition?
Lordship, that they follow the procedure laid down by Bengal Public Recovery Act.
They have
and
taken the
Lordship, they have made several errors, like the instruction that might have been placed before your Lordship
Yes.
is dated 22/07/2025 or 9th of June.
No. They have a letter written by the certificate officer to the circle officer.
Lordship, what is the date of that particular?
17/7.
17/7. Lordship, that they have written that the company, that is Me Infrastructure, as a proprietary firm represented by Ganesh Boro. Whereas Me Infrastructure is a company. And they are very well aware about that because they had earlier issued arrest warrant for 3 other directors of the company. Now they're asking that Me Infrastructure is a proprietary
No,
firm.
this is not, it is against Messrs. AK International.
Lordship,
This is regarding.
There are 2 cases, Lordship.
Yeah.
One is that is, no, Lordship, the 5820.
Order দুটা কপি আনিছো এটা কপি আনিলে কি হবে এটা ডিটেইল হেই নয়
What is the other one?
Other one is, Lordship, 5817.
You are on which
5817.
you are on 5817?
Yes, your Lordship.
5817. This 5817 is AK International.
Lordship.
Five.
AR International.
Then 5820.
5820.
There is Mara, there are 2 Me International. Me Infrastructure.
5820.
Lordship, 5817 is me infrastructure, 5820 is AR International.
No.
Ah.
5820 is?
AR International. They have filed affidavit in 5817.
Where is AR International in, which respondent?
They are not made a party to this writ petition because we are proceeding against Deputy Commissioner for not doing as per the procedure established by law.
They are not required to be made parties.
Lordship, in this writ petition, we have not made a party.
Why?
They are not a net. We can implead them here, but so far we are
These matters are pending since when?
2023.
You did not think that they are necessary parties.
Lordship, there were settlement meetings held in Deputy Commissioner's office whereby they have
But
been.
they aren't necessary parties as per you.
In this particular writ petition.
Any action, any order passed will be affecting them.
We'll make them we'll file an
You should
IA.
make them parties. And it's not that they have not proceeded. You may be correct in pointing out that the way they are, the procedures which they are adopting, they may not be the correct. But if you have to make them parties, then you can bind them. This court can bind them. They are not before this court. They simply say that we are not aware.
Only because of that, they are not before the Lordship. They are not.
They are not even parties. Why should they come on their own?
Lordship in AR International is absconding party also. They are not appearing in before the Deputy
You know,
Commissioner.
madam, you make them parties. We can come to a conclusion that in spite of service, they are not appearing. We proceed ex parte.
We'll
Now,
file an IA to that
You
effect.
file a IA in both the applications. For your own benefit, we are telling. In fact, this presentation was not proper. You should make them parties. Your grievance is okay against the officials, but you should make their necessary parties, not even proper parties. What is your name?
Miss P. Gupta.
Heard Ms. P. Gupta, Learned Counsel for the petitioners in these cases. The J. Hendrick Learned State Council has produced certain instructions, para. During the course of hearing, it is found that the grievance is mainly against the procedure adopted by the respondent authorities for execution of orders passed by the RERA. Assam. Full stop. It, however, appears that the it also appears that proceedings, Bakizai proceedings have been initiated by the certificate officer by the appropriate authority. It, however, appears that the party against whom the action is sought to be taken has the incumbent has not been made party respondents. Para. Ms. Gupta, the Learned Counsel, prays for and is granted 2 weeks' time to file appropriate applications for implement of necessary parties. Para. List after 2 weeks along with the IA that may be filed in the meantime. Same. order, huh? Pendency of this writ petition shall not be a bar to proceed in accordance with law in the Bakizai proceedings.
Lordship, in this
Item
case,
number? 13, yes.
in this case, there is a direction to produce one bylaw, Lordship, that we have not received, Lordship.
Yes, yes. Well, have the bylaw. It was on 5/8, I think. 5/8 last time.
Yes.
Get the bylaws.
Lordship.
Gwalpara case.
Yes, Lordship.
Two societies.
Lordship.
One was, you said, was not authorized.
Lordship.
Okay. Oh. Heard 3 FZ Madhudar Learned Counsel for the petitioner, para. 3. And Goswami Learned State Council prays for and is granted 2 weeks further time to obtain the bylaw of the cooperative society which was directed wide the last order dated 5/8/2025. Okay. Get the bylaws.
Lordship,
That will cleanse the issue.
can I pray for a date, Lordship?
You tell us.
As per the convenience.
List on 15th of,
September.
15th of September.
Lordship.
Yes.
Well,
Yes, PSO.
Yes, my lord.
Yes.
Kindly peruse the last order, my lord.
Yes, we have seen this.
Yes, my lord, a minute.
What is SSRC minutes?
State Secretary Review Committee.
Review committee minutes? Have you got the copy of the minutes?
No, Lord.
Get the copy of the minutes.
Lord, so give some, me some.
It was on 11/8.
Right.
This code-wide order dated 11/8/2025 had directed the Learned State Council to produce the SSRC minutes in connection with the withdrawal of personal security officer of the petitioner. Full stop. 3. J. Hendrick Learned State Council prays for and is granted 2 weeks further time. No. 3. J. Hendrick Learned Council has, however, submitted that some more time would be required. Full stop. In view of the above, 2 weeks further time is granted to the Learned State Council to produce the aforesaid minutes of the SSRC.
Okay, advance copy, my lord, as per last order, my lord. Advance
Yes,
copy.
yes.
And it's first one. Deeply obliged.
27/8/24. 27/8/24.
Right. Right.
Yes.
Senior was present here, but due to some personal reasons, my lord, he was forced to leave, my lord. Any short date may be given, my lord.
File affidavit. You want to file reply affidavit?
No, they were supposed to take instruction, my lord.
No, affidavit has been filed by respondent number 2.
Yes, your lordship, according to the last order, my lord, the opposite side was supposed to take instruction, my
I
lord.
have the instruction, Lord.
You have?
Lord.
What do you say?
They can apply in the Seva Setu, Lordship. Seva Setu online.
Though Sri N. Goswami, Learned State Council, has submitted that instructions have been received, as per which the petitioner is at liberty to apply
In Seva Setu.
under the Seva Setu, a prayer for accommodation has been made on behalf of Sri H.R.A. Chaudhary, Learned Senior Council for the petitioners. Para, in view of the above, matter is adjourned to be listed after a week.
A date may be given, my lord, kindly.
After we are seeking an adjournment and you're seeking a date, do it today.
Due to some personal reasons. he
Yes,
was
that
feeling-
personal reason is that you cannot give a date in all cases. You know how difficult it is to get a case listed. It is not on your fancies. If it's important, you should be there in the court.
He was here, lordship.
He is not here when the matter is called upon. Relevance time is now.
Okay, lordship, obliged.
Yes, next.
My lord, the respondents were supposed to file the affidavit, my lord.
Filed. Notice was issued, Mr. Taludar.
My lord, notice issued.
Last occasion, 8/8.
Yes, my lord, 8/8.
8/8.
Regarding no confidence.
Yes.
Yes, my lord.
You are protected by an interim order.
Interim order.
Okay, you filed the heard Sri S.K. Talukdar Learned Council for the petition as para. Sri N. Goswami Learned State Council prays for and is granted 3 weeks time to file affidavit in opposition. Other respondents, 6 to 11?
My lord, they have been represented.
Well, caveator?
The caveat.
Who was there?
RP Sharma.
Hmm?
RP Sharma.
Okay. list after 3 weeks for filing of affidavit. Interim order passed earlier to continue till the next date of listing.
Deeply aware.
Twenty-eight,
This case we file affidavit not.
filed affidavit.
Not.
None appears for the petitioner on call. Para. Sri N. Goswami, Learned State Council has submitted that the affidavit has been filed. Para. In the interest of justice, matter is adjourned to be listed after a week. Who is there? Yes, okay. Yes, next.
Item 17.
They have filed an IA where to file objection on the.
IA for?
They've paid for a status quo order with regard to demolition, which was
Who is
almost
for the
completed and
petitioner? Who is for the applicant petitioner?
applicant JC Gaur, Mr. JC Gaur appears.
None appears for the applicant on call, whereas the AIDC Limited is represented by Sri D. Deka Para. On the prayer of Sri Deka, Learned Council, matter is adjourned by 2 weeks to enable him to file objection in the IA. File it.
Yeah, obliged.
29 subjects.
Yes, Mr. Mazumdar.
Lordship. Lordship, I have taken stay of talking. Notice was issued, I have taken stay of talking.
Who is for the government? Yes, he is apprehending demolition.
No, sir. So, is it?
We got the instructions.
Lordship, let me.
Okay, on the prayer of three, J. Hendrik, Learned State Council, matter is adjourned by 2 weeks to enable him to obtain the instructions. Para, interim order passed earlier to continue till the next date of listing. Old matter, what it is, Mr. Chaudhary?
Milord, the matter relates to allotment of a plot of land to Gandhi Smarak Nidhi. Now, apparently, this land is being occupied by the writ petitioner in the other case. There is a clear-cut affidavit from the circle officer, Milord, that the land is under encroachment.
Okay.
And Milord, the other side has also filed after the initiation of our proceeding, when steps were taken to evict them, then they filed the writ petition wherein a stay was obtained. Now, my humble submission is, my lord, how the writ petition is maintainable, my lord, because it's not a registered body. And they have filed the writ petition, my lord, and there is a stay operating. That is how both the matters are tagged together. This Gopinath Nagar Masjid Committee, it's not a, my lord, body which can maintain a writ petition. And as far as our case is concerned, there is a clear-cut, my lord, allotment of the land by the government. We have paid the, my lord, premium also, but for the encroachment, the possession could not be given to us. We deposited the premium way back in 2010, my lord.
Now, in the other writ petition, you say there is a stay order.
Yes, regarding their
1236, 1236.
Yes.
Which order?
There is a stay order, my lord. because they challenged the notice.
Oh, there was another 463.
Yes.
463, where is
No,
463?
463, our case, my lord. The eviction order is at page 40 of the 1236. Page 40.
No, in 1236, we are trying to locate the stay order. Where is the interim order? Was it passed in your case in a separate order?
No, I think, my lord, in their case. In any case, my lord, now the matter needs to be decided, my lord.
Yes, we are deciding that.
And we have also raised maintainability issue, my lord, of their writ petition.
Yes.
That
Yes,
is also.
madam.
Yes.
Lordship, Senior Counsel, Mr. B.D. Das is appearing. He is on his way. He is coming, Lordship. Lordship, they may start.
24/7, 24/4.
Yeah, no, absolutely. Huh? Yeah, no, back to some night. Huh? Yes, I think. Well, I'm sorry, my lord, there is no stay order. Lord.
There is no stay order, no
Yes,
stay order.
yes. But then because they are on occupation, my lord, land could not be given to us.
And what is their cause of action then?
Their cause of action is the impugned notice, eviction notice. Page 40 of their writ petition.
And your cause of action?
My cause of action is, my lord, because the government could not hand over the land
You
because they are in occupation.
give us the land. That is
Yes,
your.
yes,
And they said that they are aggrieved by the eviction notice.
yes.
Okay. So what is there to decide, madam?
Lordship, he is coming.
Let us see your till that time your allotment order.
Yes, my lord.
We take up then 463.
Yes, yes. My lord will first come to page 22.
Oh,
I am directed to say that the Doug number.
time has gone very fast today. Can you complete it?
That is also there, my lord.
Mr. Tiwari, you should be in the same case. You should be in the same case. There is no waiting then.
For waiting for the case. So I'm expecting those very dividends by way of a date, if not anything. Because it is 2015 matter. So
We'll have your matter. I don't think it can complete today. If you can 15 minutes, if you can try, you can try. Otherwise, we'll have it some other day.
Yes.
Half. No. But these are all matters. We can have day after tomorrow.
Yes, madam.
Day after tomorrow. And Mr. Tiwari, your matter, which off? Okay, all matters day after tomorrow.
Lordship, fix it day after tomorrow.
Day after tomorrow. Okay. Do it, I'll keep.
Lord, day after tomorrow, I'll be going early. Could it be on Monday next, Lord?
Okay. Or Tuesday, is it okay?
Tuesday, I'm not there.
Monday we'll try. Monday. In fact, Monday it will be better.
Yes.
Monday we'll finish up the list early.
Yes.
It doesn't matter. Monday. Madam, Monday is okay for you?
Yes, Lord.
Positive of time, Monday kore diyo. And your is still be day after. What is your matter?
the land of a tribal in a tribal belt allotted to a non-tribal. This is the second round of litigation. In the
Private
earliest-
respondent.
Yes.
Who?
A private respondent, my lord, is a non-tribal.
No.
They are
Who's the counsel?
represented by, I believe, my lord, the council, my lord, that's, the councils will not also keep on changing actually, so. I think.
Okay, we'll have it day after tomorrow. your
Yeah,
matter.
we'll
And Mr. Chaudhary's matter on Monday.
Monday.
Okay. Bakshi na lagega.
Day after. Yeah. Very good.
The meeting was a power wish. Take one tattoo. Take one.